May I please your Lordship? Lordship, I beg to mention item number 38 and 39 as my senior Mr. S.K. Medi is out of station. Lordship, yesterday we have submitted the affidavit in opposition in item number 38. Lordship, matter may be taken on 18th of May.
Lordship, I am for the petitioner. Your Lordship may take it up on 18th of May.
No,
because-
date I will not do.
Your Lordship, there is an urgency. That's why your Lordship.
Then we'll take it up together.
Well-
You can't on your own decide which date it will be taken.
Yesterday, they filed one affidavit.
Then we'll take up the matter today.
That is a problem. Mr. S.K. Medi.
Firm date is not possible.
Any short date?
Either you agree or 1 week I can adjourn.
1 week.
On the prayer of learned counsel for the respondent made with the consent of the other side. Admission hearing of this is admission hearing of this matter since adjourned for a week. Let this matter be listed again by tagging the affidavit filed by
The respondent.
by
Respondent
the
number 1.
respondents with the record of this case. Same order in 38 and 39.
Made please, Your Lordship. Item number 12, my lord. I am not pressing this, my lord. Withdrawal, my lord, with the liberty, my lord.
Mr. N.J. Dutta, learned counsel for the petitioner submits that he has instruction to withdraw this petition with liberty to file a fresh. Since the prayer is not opposed by the learned government advocate Assam, same stands allowed. This weak petition stands disposed of on withdrawal with liberty as paid for.
I am obliged.
My please, Lordship, I beg to mention item number 45, Lordship. Orders, Lordship. As my senior is out of station, Lordship, matter may be passed out for today, Lordship.
You are for whom?
I'm for the petitioner, Lordship.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks. Please take.
Lordship, 1 week, it may be 1 week.
No adjournment for 1 week here.
Much.
May it please your Lordship, in item number 17 of today's causeless motion matter, so I have filed one additional affidavit, Lordship, that may be called for.
Yes.
May I please, Your Lordship, item number 28 may be passed over for a week. 28 item number.
You are for whom?
I am the petitioner.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks. List accordingly.
Must.
May I please, Your Lordship, I beg to mention for item
20.
41, on behalf of Mr. S.K. Talukdar. I've taken the consent of the other party.
Yes, this is connected with item 40.
Yes.
You have informed the other side.
Yes.
Item 41 is readable. A prayer for adjournment has been made on behalf of the petitioner on the ground that the arguing counsel is out of station. Since the prayer is made with the consent of the other side, same stands allowed. Let this writ petition be listed again after 2 weeks along with item 40. Yes,
Bless my Lordship.
May I please your Lordship? Lordship, I beg to mention for listing of a writ petition, your Lordship, the matter pertains for regularization of salary for a grade 4 post employee, your Lordship. The matter was last posted on 20th/1/2023 and have not been listed till yet, your Lordship.
When
Any
you
date
want?
as per convenient of this court, your Lordship.
first week of June.
Oblige, your Lordship.
Hey, please, Lordship. I'm paying for listing a matter for admission, Lordship.
First week of June. Yes.
Lordship, I beg to mention WPC number 4839 of 2018. Lordship, the matter was last listed on 27.
Second week of June.
Pardon, Lordship,
Second week of June.
second week.
Yes.
Bless Lordship. Lordship, I would also like to mention WPC number 6708 of 2022.
Hmm.
Same.
Same order.
Bless Lordship.
May this Lordship, I beg to mention 3 items for listing. Lordship, the 3 items are connected. The individuals are different, but the 3 items are connected. The matter was last posted on 03/12/2020.
Second week of June. Second week of.
Obligation.
Lordship, I beg to mention item number 50, Lordship. The applicant has filed an IA for vacation of an order. We need 2 weeks time to file a objection to it.
Item.
50, Lordship. 50.
You
I'll
have
inform
informed the
Mr. M.U. Mahmood, sir. I did not find him in his table.
No, but if he comes and objects, then I'll take up the matter.
Lordship,
You are for whom?
I am for the applicant, respondent number 1, Lordship, in the IA.
What is the matter about?
Lordship, they have filed an IA for setting aside the disposed of order, Lordship.
You wait, let the matter be called up, then we'll see. Mr. So-and-so, you are Mr. N. Islam. And counsel for the petitioner submits that he has instructions from his client to withdraw this writ petition. Mr. B. Chakravarti, CBC appearing for the respondent, does not. Oh, there is an objection filed.
Lordship,
You have
no
objection.
objection filed, Your Lordship.
You don't have any objection.
No instruction, Lordship, from the authority.
Mr. B. Chakravarti, learned CBC submits that although he had taken a stand in the matter on the previous day, yet there is no instruction from his clients to object to the prayer made by the petitioner's counsel for withdrawal of this writ petition with liberty to file a claim. In view of the above, the petition stands disposed of on withdrawal with liberty to file a fresh. Yes.
Complex.
I stands disposed of. In view of order to also, I stands.
May I please, my lord, here appeal is pending before the my lord appellate authority, my lord. And my lord, the impugned order lordship will find at page my lord 61.
Page 61.
Page 61, my lord.
Yes.
Serial number my lord 14.
You are challenging his selection.
My lord.
File an appeal.
Yes,
Appeal
appeal
is
is
pending,
filed,
my
my lord, that is pending, my lord. Page 67.
Page
67, my lord.
let the appeal be disposed of within 60
Yes.
days. Heard Mr. M. Mondal and counsel for the petition also heard Mr. P.C. Chutia Lanet, additional senior government advocate Assam appearing on behalf of the respondent numbers.
And for number 2, Lordship.
Respondent numbers 1 and 3 to 5. Mr. S. Dr. Lanet SC 3 to 5 and 7. Mr. S. Dr. Lanet. Standing counsel, Revenue Department Assam has appeared for respondent number 2. By filing this writ petition, the selection of the respondent number 6 for appointment as Pradhan of Pradhan of charge number 21, Uttar Athiyavari Revenue Village, Govardhana Moja under Bornagar Revenue Circle in the district of Borpeta has been assailed on the ground that his selection is in gross violation of the provisions laid down in clauses 10(7) and 10(9) of the advertisement notice dated 03/09/2022, as well as the provisions of clauses 162(a), 1 B and C, interbracketed A, B, and C interbracketed of the executive instruction framed under the Assam Land and Revenue Regulation. First up, the learned departmental counsel have pointed out that the petitioner has already preferred an appeal before the respondent number 7, and therefore this writ petition be closed with a direction to dispose of the appeal in a time-bound manner. Mr. Mondal has also agreed to such a recourse and has prayed for an interim order of protection. Taking note of the submissions made at the bar, this writ petition stands disposed of at the stage of motion hearing with a direction upon the respondent number 7 to hear the appeal referred by the petitioner and dispose of the same within 60 days from the date of receipt of a certified copy of this order, after giving an opportunity of being heard to the respondent number 6. First up, as an interim measure, it is provided that no order of appointment will be issued in favor of the respondent number 6, if not already done, without verifying the allegations made by the writ petitioner. Writ petition stands clear.
My lord, 3, my lord, I say identical issue, my lord. Only lot number is different, my lord. Here, my lord, appeal lordship will find at page 1 on 3. my lord.
May I please, Lord? In this case, Lordship, in this case, already court has adjudicated the matter. Dismiss the earlier related litigation. Lordship.
So where is the order?
Yes, Lordship. Page 79, Lordship.
Appeal order to court. I put appeal to the-
Yes, Lordship. 386.52.
Appeal order.
He has not fulfilled the S criteria, Lordship, as per advertisement.
So you are not eligible.
Yes, my
Yeah.
lord, that order, my lord, passed by this, my lord, honorable single judge, that has been challenged before the, my lord, division bench.
Yes.
And there is an order lordship will find
One or
at page, my lord, 1 on 0.
zero. One on zero. Echodos.
Operative fund, my lord, on triple on, my lord. Now ultimately, my lord, a review petition has been filed. Before this, my lord, honorable single judge. That is not, my lord, listed today. And, my lord, so far the, my lord, subsequent, my lord, instruction is that the petitioner is, my lord, qualified by yes, because the, my lord, the notification was changed, modified.
No.
Minimum age is, my
You
lord,
preferred a review against the order passed is in WPC number 386.
yes.
Where is the, what is the number of the review?
Review listed, Lordship, Monday listed it is.
Listed.
Yes, Lordship. Review petition number 58 of 23.
All right, I heard Mr. M. Mandal and counsel for the petition also had so and so for the revenue department Assam. Let this petition be listed again on Monday for
Monday.
motion to be taken up along with item number
Item number 46.
46. The registry may indicate the same in the cause list.
Okay.
Oblations.
We'll go down.
Monday.
Item number 46 of Monday's list.
Maybe Lordship.
Review petition number so and so to file over review.
Maybe Lordship. Lordship, the petitioner is serving in the Assam Rifle in the
Say
rank.
Monday list of file over, you'll get it.
But the petitioner is serving in the Assam Rifle in the rank of Subedar, my lord. He was deprived from the promotion to the next rank, Subedar Major, my lord. He has represented to the department and he was informed that due to the lack of ACR,
So we'll issue notice at this stage.
my lord.
Heard Mr. V. Kumar, counsel for the petitioner, the read petitioner herein is serving as a Subedar oblique GD in the Assam Rifles, aggrieved by the failure of the authorities to consider his case for promotion to the rank of Subedar Major. The petitioner has approached this court inter alia contending that the authorities have acted in an arbitrary manner in denying him a consideration for promotion. First, Ms. B. Sharma, Lalit CGC 6, time to obtain instruction and file affidavit in the matter. NOM 6 weeks since Ms. Sharma has appeared for all the respondents. No formal notice, extra copies.
Lordship, another four, I'm not appearing. 4 is a private respondent.
1, 2, and 3, no formal notice is required to be sent to the said respondent. Extra copies of the writ petition be furnished in requisite in numbers to the learned CGC so as to enable her to obtain instruction and file affidavit. Petitioner takes steps for service or notice upon respondent number 4 by registered post.
My lord,
Okay.
deeply lordship. May it please your lordship. Well, in this case, the by the impugn order, my lord, at page 16. Gambura of another village has been appointed as in charge Gambura of the present village, my lord. But the rule says that, my lord, he should be resident of that.
So already appointed.
Appointed, my lord. I have filed a representation before the deputy commissioner, my lord. There's a deputy commissioner decide the
No,
representation.
no, if it's already appointed, it cannot be.
No, in charge appointment, my lord, not
Huh?
regular appointment. In charge appointment.
Not regular appointment. Lordship will find the order at page 18, my lord. No, sorry, my lord, 16.
So show me the rule which says you cannot appoint an in-charge Pradhan from outside the revenue circle. Where is the rule?
In the advertisement, Lordship has seen the advertisement. That in the advertisement, there is a criteria that he should have the landed property and resident of the village.
Where is the advertisement?
In the petition, my lord, I feel the next day.
Not an exclusion.
Next week,
My lord.
on the prayer of Mr. Ayed Sikal and counsel for the petitioner, this matter stands adjourned for a week so as to enable him to place and record the advertisement, the relevant advertisement notice based on which the allegation is made in this petition. Mr. J.K. Goswami, Learned Additional Senior Government Advocate Assam, as well as Mr. S. Dr. Learned SC Revenue are present on behalf of the official representatives.
Item 6.
May I please, Your Lordship? My lord, in this case, the petitioner was appointed on compassionate grounds in the year 2010, my lord.
What petitioner was what?
Appointed as junior assistant in the year 2010 on compassionate ground, my lord. But he could not join there, my lord, due to the obstruction of local youths, my lord. Then he came to the respondent number
When was he appointed?
in the year 2010, my lord.
And now he has come for an order to allow him to join. We'll issue rule and hear it after 10 years. We will not entertain this petition. Why 10 years?
My lord, he was suffering from mental illness, my lord, during this.
Can't help it. Election made 10 years back. Now you want a direction to appoint him.
But he brought the same to the notice of the respondent number 3, my lord, by filing a representation, my lord. My lord. Please,
Sorry, Mr. We will not entertain this petition. Where is his order of appointment?
appointment, my lord. Page 17, my lord.
So where is the proof that that post is still vacant?
There is no proof in this regard, my lord. Instruction maybe whether post is vacant.
No,
or not.
you have to make out a case.
Hello.
Throw up some papers to the court and ask the government advocate to defend that. That approach will not be acceptable. You make out a prima facie case, then we'll ask them. His appointment is pursuant, not pursuant to some selection. This
No, my
is
lord.
on
Compassionate.
Where is the recommendation of the SLC?
A recommendation of SLC is not there, my lord, but in the appointment letter, it is itself mentioned, my lord. In the pursuance of finance SIU department's approval, so and so dated.
You
at-
want time or I'll pass the order today?
My lord,
I'm not entertaining this matter.
my humble prayer, my lord. At least notice may be.
No, it cannot be done. By our orders like this, we are creating problems for the institution.
My lord, if the post
You
is-
may make it, please, but that's not how law works. 10 years back,
Yes, my lord.
not even 10, 13 years
Yes.
back, what was the situation? You have to tell us now. How can this order be implemented? We pass an order, then comes a contempt, then after 2 years, it is found that nothing can be done. Then again, a fresh round comes. This business has to stop. You show me how that this post is still vacant, nobody has been absorbed, and it can be implemented if an order is passed, I will pass an order. Otherwise, sorry. You want time or I'll dictate the order now?
Then time may be.
All right. On the prayer of Mr. H. Ahmad Chaudhary, and counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable him to obtain instruction and demonstrate before this court that the recommendation made in the year 2010 for appointment of the petitioner on compassionate ground is capable of being implemented today after a lapse of nearly 13 years. Full stop. Ms. S. Borwal and the government advocate Assam is also present before this court. List the matter accordingly. Come up with clear materials, we'll pass an order. Otherwise, it will be dismissed. Yes.
Yes. Obliged.
Hey, my lord, your lordship will find, my lord, at page, my lord, 38, the DL3 recommendation. in favor of the my lord petitioner. Is 38, my lord. Last paragraph, my lord.
Page
Yes,
38.
page 38. Last paragraph, my lord.
Then what happened?
My lord. Now, lordship kindly see, after that, my lord, page 41, he has submitted the my lord, recommendation.
Page?
Page 41.
No decision by SLC.
Yes, my lord, 1, 2, 3, there was an state level meeting, but my case was not placed before this my lord, SLC. So limited period, my lord, let it be placed, my case, in the next DLC, my lord. That must be.
Notice may go lordship instruction have to buy, it may be placed.
No, I
But
enquired
Mr. M. Mondal, counsel for the petitioner.
It is may-
after
The
7 years, my
petitioner
lord.
hearing had submitted an application for appointment on compassionate ground on 31/8/2015 after the premature demise of his father on 08/08/2015 while in service under the government of Assam. First up. By the resolution adopted in the meeting held on 14/2/2023, the district level committee had recommended the application of the petitioner for appointment against a grade 3 post. First up. The prayer of the grievance of the petitioner is that the matter has not yet been considered by the SLC. Hence this writ petition. Stop. Ms. S. Borua, learned government advocate Assam, prays for some time to obtain instruction in the matter. NOM 6 weeks. You are appearing for
Yes, lordship.
all.
No, 1, 3 and 4.
Says Ms. S. Borua has appeared and accepted notice for response numbers 1, 3, and 4. And Mr. S. Datta for response number 2.
I'm for 2 and 6.
Response number, Mr. S. Datta, learned SC PNRD, Assam for 2 and 6. Services notice is deemed to be complete in this case. Extra copies of writ petition be furnished to the learned department council. It is made clear that pendency of this writ petition shall not constitute a bar for the SLC to consider the recommendation of the DLC or the petitioner in accordance with law.
Developed six. May I please, your
Yes.
lordship? My lord, the matter relates to, my lord, selection and appointment of Gaunburas in the district of Gwalpara. My lord, we have challenged an advertisement wherein, my lord, our lords, wherein we have already been appointed.
Where is
And-
the advertisement?
My lord, the advertisement is at page 150, annexure 18, my lord.
Lordship, the similar matter.
No,
on
it was
4,
not-
5 lordships. It was, my lord, they listed. That same advertisement, same, my lord, district lordship. Lordship was fixed it on, my lord, 31/5 lordships. List the matter along with the that.
My lord, I am aware about that, my lord, writ petition, my lord. The
Read petition
prayer-
number 2395, 2023.
My lord. My lord, with all respect to my respected senior sense as a submission, my lord. Our grievance is slightly different with that, my lord. Our appointment, my lord, has already been examined by this honorable court in a series of petitions, my lord. Challenges were made. But that challenge, my lord, has been dismissed by this honorable court, and the writ appeal order is also there in our favor, my lord. And on the strength of that, my lord, till date, we are working, although, my lord, no salary had been paid to us. But in the very advertisement, my lord, the lots wherein we are working, my lord, on the strength of our appointment order, my lord, those lots has also been advertised for the purpose of fresh filling up, my lord. That's why, my lord, we are aggrieved and challenging this advertisement, my lord. So, my lord, may issue notice, and at least in our lot, my lord, the recruitment process may not be finalized, my lord.
My lord, I have
That
an
is our
objection.
limited prayer, my lord.
Oh, I have an objection. My lord, that advertisement, my lord, they have to appear, lordship.
No.
There
We
is
are
no
already-
process for, my lord, that the honorary teacher, my lord, to, my lord, regular.
This is teacher.
No, my lord, honorary Gaubra lordship.
My lord,
I'm sorry.
my lord, yes, yes, my lord. My lord may be pleased to take up our appointment order, my lord. Is that I have annexed, my lord. Is at page 54, my lord. My lord, may kindly see our appointment order issued by the Deputy Commissioner of the concerned district, my lord. At page 54.
Yes.
My lord, page 54 is the appointment in the interest of public service and in pursuance of the guidelines communicated in the government letter number dated so and so. Sri so and so Chakraborty of so and so is hereby appointed as honorary Gaubura of the revenue village, Satimari under Lakhipur Circle in the district of Gwalpara. Now, my lord, this nature of appointment had been issued by the Deputy Commissioner on the strength of a policy decision of the government. That policy decision, my lord, may be pleased to find I have annexed at page, my lord, annexure 1, page
Now, what is
46.
this honorary Garbura? What does it mean?
My lord, they are working without any salary has been, my lord, they have not paid any salary. But it is a, my lord, we have been otherwise working with all the full-fledged duties and the nature of duties assigned to the Gaumburas, and the government is also accepting our duties, my lord. But we have not been paid the salary. Another writ petition has been filed, my lord, before this honorable court. It is also pending. That in that writ petition, my lord, we have claimed for our salary, my lord, and this honorable court is examining that whether we are entitled to the salary or not, my lord. I have also annexed that order in my this petition also, my lord. So, my lord, at this moment, my lord, my respectful and limited submission, my lord, may be examined, my lord, that whether the recruitment process in the advertisement wherein our lords has also.
So what you
my-
want is there should be no recruitment and you should be continued in service.
My lord, my lord, this honorable
No,
court,
no.
my lord.
please give
My
a
lord, yes,
straight answer.
yes, my lord, yes.
How
my
is
lord.
that permissible?
No, my lord, because this,
Why, tell me what process was followed while appointing you?
my lord, the process has been at annexure 1, page 46, my lord.
What was it?
My lord, it was a guideline framed by the government, my lord, for the purpose of appointment of the honorary Gaumburas.
There
My lord,
can't-
my lord, I am coming to that, my lord, with the all my respectful submission, my lord, this guideline had been put into challenge before this honorable court in a writ petition, my lord, in the year 2005. In that writ petition, my lord, the guideline as well as our appointment has been, my lord, set aside by this honorable court. Then, my lord, writ appeal was prepared, and the writ appeal has also upheld the learned single judge's order, my lord. And ultimately, my lord, what has happened in both the writ petition as well as in the writ appeal, my lord, in the writ petition, as we were not parties, my lord, therefore, my lord, we have again preferred a review petition before this honorable court, that, my lord, without making party, my lord, our case had been adjudicated. Then, my lord, this honorable court has directed the writ petitioners of the original writ petition to make us party and then to proceed further. But, my lord, in the original writ petition, my lord, the writ petitioner did not move before this honorable court. No party was, my lord, impleaded, and accordingly, that writ petition was also dismissed. My lord, on the strength of, my lord, as there is no, my lord, may be pleased to find the order, my lord. I have annexed, my lord. Just for a moment, my lord. I am taking my lordship's precious time, my lord. No, order. My lord, may be pleased to find that order, my lord.
Yes.
At page 140, my lord. Page 140, my lord. The entire facts has been narrated, my lord. As a result, my lord, our,
So, Mr. Bhuya,
My lord.
the court is willing to issue notice,
my lord,
but beyond that will not be possible. If you want a detailed order, I can pass it so that you can test it. You have not made out any prima facie case. How can you stop regular selection to accommodate you in a post where your appointment was without any process of law and on an honorary basis? You
Lord.
can't get salary on this basis of this appointment.
my lord, our appointment, my lord, on the strength of a policy of the government, my lord.
That
And
policy will not.
that policy, my lord, the government has, my lord,
All
initiated.
right, then
my
you
lord.
continue as per the policy as honorary Gaudira.
But, my lord, if the appointment is made in our lords, my lord, then our status would be nowhere, my lord.
Yes, that is how it should be.
My
That
lord,
is how
then-
your order, your appointment was purely temporary.
No, my lord, it is not temporary. My lord, may
Oh,
kindly see the
oh,
nature of
look at the-
appointment, my lord. Huh?
Have a look
Temporary,
at,
yes,
you have not,
my lord.
No, no.
please read page 55, Mr.
My lord, my lord, my lord, my lord.
You have not read the order. Please
No.
see clause 1. Please read it.
My lord, this appointment is purely temporary and may be terminated at any time without. My
So
lord, this is
why
the.
are you saying it is
No,
not?
my lord, I am absolutely sorry, my lord, for my this statement, but my lord, this is the language used in in the regular appointment also, my lord. My lordship is well aware, my lord, if a regular appointment is made, my lord, in that appointment order also, this is the language used, my lord.
Mr. Bhuya,
My
where
lord,
there
my
is a
lord.
semblance of right,
My lord,
we understand the difficulties.
my lord,
And there is a semblance of right which can be enforced within the ambit of
my lord.
well-established legal principle,
My
the
lord.
court is always open. But when you come at petitions where the prayer is completely divorce the jurisprudential basis, it becomes very difficult. It becomes very, very difficult.
No, my lord,
This was a fortuitous circumstance. Some policy, somebody said you continue as honorary, all right, you continue.
my
It
lord,
is your matter, you are satisfied.
my
Now you are saying because we are appointed like this, don't have a regular selection, don't allow regular appointments to be made, stop it by an interim order. These kind of orders are creating havoc in the administrative sphere. How can it be done? You address arguments on that. I'm not stopping you from addressing
My lord.
argument.
my lord.
You want to
once-
say that argument I'll address later. Today give me a stay. That is not possible. We cannot pass these orders like this because
Mal-
we have to be convinced that there
Yes,
is a
yes,
case
yes,
made up.
that,
You
my
are
lord.
not addressing any argument how it can be done.
No, my lord,
What
they-
you want is issue notice,
No, no,
give
no,
a stay, some other day I'll argue.
no, that is
2
not.
years will go,
That-
people will,
That
appointments
cannot,
will be
that
stalled.
cannot be, my lord. I am duty bound to at least satisfy prima facie, my lordship, my lord.
Show me which
my lord.
principle.
My lord, if my lord may be pleased to take
And
up
Mr.
the,
Bhuya,
my lord,
what this court is interested in
My
and will only act upon is on sound legal principles.
Yes, yes, ma'am.
Nothing else.
my lord,
Nothing else.
the,
Any order of the previous courts, previous orders,
my lord,
if it is based on a legal principle, on some logic and lays down a ratio, it is binding on the court.
my lord,
I will follow it. Otherwise, difficult.
my lord.
Otherwise, those orders will be treated as passed on those facts. So you tell me, what is the right that you can enforce here? What is the right? Can you
Lord,
enforce a right against those applicants who are subjecting themselves to a regular selection process pursuant to an advertisement? Under which jurisprudential principle can you do that?
Lord,
You have been just picked up, handed over appointments, honorary basis, no salary, nothing, temporary. All right, fine. But now you want to chip in and say that, sorry, since we have come in, nobody else can come in by a regular process and pay as a salary. How is this kind of a petition maintainable? You address arguments, satisfy the court. I am willing to pass an order.
my lord. My lord, my argument in that, my lord, query of my lordship's, my lord, is very limited to the extent of a policy of the government, my lord. The policy which the government has adopted, my
Which
lord.
policy? What is the policy? Let us see.
My lord, may kindly, at page 46, my lord.
Hmm.
Page 46 is a policy of 10th of January 2000, my lord. My lord, what has happened at that time, there was no Gaungura system in the district of erstwhile district of the Gwalpara. And in this manner, my lord, the Gaunguras were appointed in those districts, my lord. This is the policy appointment of honorary Gaungura, honorary additional Gaungura. I am directed to say that the government of Assam has decided to appoint one honorary Gaungura in each of the revenue villages of the state, excluding the 6 scheduled areas. For this purpose, a revenue village would mean a fully cadastrally surveyed and inhabited village, the land records of which are properly recorded in the village Jamabandi and would not include any non-cadastral village, uninhabited village and forest village. This appointment would be made by the deputy commissioner on the basis of the recommendation made by a selection committee consisting of a chairman as indicated below, an additional deputy commissioner revenue as member and deputy commissioner, my lord. So, my lord, our appointment was not that we have been picked up and appointed. We faced a selection process, my lord. And on the strength of that selection, my lord, we had been appointed, my lord. And my lord, the appointment only, my lord, the condition is that, my lord, only the condition is that this appointment will be absolutely honorary and the appointee shall not entitle to any pay, allowances, honorarium, or any other financial perk from the government. They would also not be entitled to any claim of financial benefit in future. The persons to be appointed as honorary Gaupura and honorary additional Gaupura shall have the minimum educational qualification of passing high school living certificate examination. Lord, which is the, at this present day moment also the minimum qualification is the
So now the
HSLC.
persons sought to be appointed by the impugned advertisement.
My lord.
They will also be honorary.
No, no, my lord, it has not been said that they will be honorary, my lord.
Then how can you stop them? Your category is different, their category is different.
Then, my lord, in the same lot or the, my lord, same villages, there will be two Gaupura, one honorary and one
That is
Sarkari.
their problem, not not the court's problem.
My lord, because it is the problem has been created by the government, my lord.
That always happens. Is
My
this the first time?
My lord,
Is this the first time this has happened?
no, 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 my
Then
lord, it is
You are
happening, my
saying
lord.
problem has been created by the government. Is
Now,
this
my lord,
something
kindly,
new?
my lord, may kindly appreciate, my lord, kindly appreciate, we have, my lord, rendered more than.
Somebody's job is to create problems, somebody's job is to solve it. Let it be like that.
My lord, may kindly appreciate, my lord, we have been working more than 23 years, my lord. Now, at this moment, if we are ousted.
Yes,
My lord,
whether you will have a right to continue as
My
an
lord.
honorary Gaupura, that is the limited aspect of the matter we can examine. But here also you are hanging on a very fragile thread because it doesn't confer, it's not a statutory provision. Your right is not protected under any statute,
my lord,
any rules. Suddenly a random policy,
My
appoint
lord.
honorary
My lord.
Gaupura. Why
lord.
would people work without any remuneration, first of all? How can there be appointments to get free service from someone?
But that's why, my
These
lord,
are
in my,
matters,
in
I don't
my
know
another
whether-
petition, my lord, we have prayed for our
All right,
regular.
we'll just issue notice at this stage.
Then, my lord, may this process, in our lot may be made subject to outcome of the writ petition, my lord. That observation may be given, my lord.
That is always there. Huh?
Mal.
Mr. A.R. Bhuyan and counsel appearing for the writ petitioner. The petitioners hearing claim to have been appointed as honorary Gaupura in terms of a policy decision of the government notified on 10th of January 2000. Mr. Aggrieved by the advertisement notice dated
6942.
what is the date of this advertisement?
My lord, yes, my lord, it is at page one, it is,
What is the date of the
yes,
advertisement?
yes, my lord, I am coming, my lord, it is in the last page. 18/4/2023, my lord. My lord may find at page 161 and it's just below this.
Bracket annexure 18. Bracket close, issued for recruitment of Gauburas and additional Gauburas for the district of Gwalpara. The petitioners have approached this court internally concluding that if the advertisement is given effect to, then the petitioner's services will be terminated. Full stop. As such, a prayer has been made for an order of interim protection. Full stop. Mr. J. Hendik, Learned Standing Council, Revenue Department, Assam, on the other hand, has seriously objected to the prayer and submits that the process initiated through the advertisement notice dated 18/4/2023 is as per the requirement of the statute and for recruitment of Gauburas / additional Gauburas who will be entitled to remuneration. First of the appointment of the petitioners being dehouse the rules and on purely honorary basis, they cannot continue at the cost of the regular recruitees. Full stop. The aforesaid aspect of the matter would call for detailed examination by this court. As such, issue notice of motion returnable in 6 weeks. Who is appearing for whom?
I am for the respondent one lordships.
Since Mr. Hendik has appeared and accepted notice for respondent number 1.
I am
And Mr.
2 to
J.K.
5.
Goswami for additional senior government advocate Assam. For
2 to 5.
numbers 2 to 5. No formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable them to obtain instruction and file affidavit. Register to list these cases along with WPC number.
WPC number. 2395 of 2023 lordship.
2395 of 2023, which is stated to be analogous to this proceeding. Heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, I am not inclined to pass an interim order at this stage. It is, however, made clear that appointment, if any, made under the advertisement notice dated 18/4/2023 will be subject to further orders that may be passed on this case.
Obliged, highly obliged. May I please? My lord, lordship kindly see the my lord order at page my lord 47.
Page?
Page 47, my lord. And my lord, operative part lordship will find at page 50. Page 50, my lord. My lord, para 2 direction part, my lord. The approval for conducting the recruitment process to the post of supervisor under the 25% quota has already been conveyed by government letter number so and so, so and so, so and so. The same may be expedited. Now, till date, my lord, no process has been my lord, started. Despite this order issued by the my lord, Secretary of the Government of Assam.
You obtain instruction, we'll see.
Yes, my lord, prisoner is claiming for promotion, my lord. Her age is over, anyhow, my lord, that has been condoned. I have seen it. My lord, regarding recruitment process, my lord, promotion, initiative or steps for promotion, my lord, the court has passed this order according to pass this order in appeal by the secretary.
Some is that no steps have been taken by the department in terms of the order dated 18/11/2022, bracket annexure 11, passed by the departmental secretary, Mr. P.C. Chutia, learned additional senior government advocate Assam, praised for and is granted full time to obtain instruction and appraise this court as to whether any steps have been initiated under the order dated pursuant to the order dated 18/11/2022. 2 extra copies of writ petition be furnished to Mr. Chutia. Let this matter be listed for motion again after 2 weeks.
Lord, may I, my lord, pendency may not be bar to them. My lord.
No, it's motion, they will not be. Wait for 2 weeks.
Oblige, lord.
May to the lordship, regarding recruitment by the SSC in the Central Armed Police Force. Here is covered judgment of your lordship. Your lordship have covered judgment on this matter.
It's covered.
It's covered, lordship, but only the delay part is there, lordship. Yeah.
Covered matters will pass orders. What delay? And all the petitioners,
Only two. They are OBC candidate.
2 petitioners, OBC candidates.
OBC candidate.
So similar order disposed of CGC SS. The petitioners over here. Similar order disposed of.
Oblige, lordship.
My lord, the matter is to my lord transfer, my lord. My lord, the petitioner, my lord, is transferred from my lord, the frontier headquarters, my lord, the Tezpur to my lord, the 55th battalion, my lord. That is my lord, Pithoragarh, my lord, the Uttarakhand, my lord. That is my lord, page annexure 16, my lord, page 88, my lord.
You are now posted where?
At present, my lord, the frontier headquarters, my lord, Tezpur, my lord.
Tezpur.
Lordship, my lord.
When were you posted there?
My lord,
When was the posting made?
2017.
2017.
2017.
Lordship,
5 years.
5 years, lordship.
So what, you don't want to go out of Tezpur?
My lord, what happened, my lord, my petitioners, my lord, minor soil, my lord, he is a special asylum, my lord. He is a my lord suffering from mental retarded, my lord, as well as my lord cerebral epilepsy, my lord. My lord,
So that's correct. So you want to spend the rest of your life in Tezpur, is
no,
it?
my lord, that is not, my lord. My lord, now, my lord, his son is, my lord, 9 years old, my lord. And treatment is going on, my lord, at the mental health, my lord, Tezpur, my lord. My lord, he is the, my lord, caregiver, my lord, of the, my lord, the petitioner's son.
So Mr. Dihingia, I'm asking you, this problem, God forbid, if it continues, then your client will never go out of
No, my
Tezpur.
lord, that is no, my lord, he is the, from my lord, my lord, kindly see, my lord, I have a statement, my lord, paragraph 2, my lord.
Oh, please answer the question. I'm asking you a question, you are telling me which paragraph, which page. Is it your case that till, as long as your son is there with you, you will not go out anywhere out of Tezpur?
No, no, my.
Then what is the,
Undertaking, he gave undertaking in earlier representation also, my lord.
Hmm.
Then only at this, my lord, his son is from cure, my lord, my lord. Then, my lord, he may anything, any place, my lord.
Lordship,
this is a
It's a
very
five-
sentimental issue.
Fifth time, my lord, my lord.
Petitioner's son, what do you say?
according to him, he is 70% disabled, Lordship.
Hmm.
And what he had not mentioned, Lordship, but one transfer order is state, Lordship, that is still in operation. So I have already talked with the department that that in the event that the order is already there, not this transfer order, that is already state, the previous order that is
State by
still
whom? State
by
by
this honorable
Yes,
court.
lord.
where,
so-
which petition is still pending?
Yes, lord.
Yes, Lordship, that is why I even asked them to pass, if possible, any,
Annexure-
because without
What
vacating
is the
that,
case number? What is the case? number?
Annexure 8, lordship, page 61, lordship.
that is still in operation. So I have even asked them,
Then how can you pass another?
yes,
transfer
Lordship, that
order?
consequences I have already intimated, and they are possibly they will do something in this matter, Lordship. Without vacating or without,
WBC 5755 of
Lord.
2019.
I have talked with.
I heard
authorities,
Mr. Alan
Lordship.
Divingal, learned counsel for the petitioner, also heard Ms. B. Sharma, learned CGC appearing for the respondents. After hearing the submission of learned counsel for the parties, this matter is directed to be listed again in the next week for motion, along with WPC number 5755 of 2019. In the meantime, the learned CGC to obtain and appraise this court as to how the impugned order of transfer could have been passed by the authorities during the pendency of WPC number so and so, wherein a stay order is operative.
Lordship,
Obliged, lord.
May I please, lordship? Petitioner before lordship is an assistant accounts officer in the PNR department, Panchayat and Rural Department lordship. He has challenged the final combined inter-C gradation list, inter-C seniority gradation list prepared on the basis of date of birth, and there is no service rule. So length of service, it is to be determined on the basis of length of service, lordship. Lordship petition, may kindly come to page 41. He was promoted to the post of accountant in the year 1989. So is page 41, lordship, on creation of
Yes.
lordship, page 41 is on creation of 219 assistant account officers.
Hmm.
Accountants were redesignated as assistant account officer. May I please read, lordship, 41. In pursuance of creation of 219 19 number of posts.
So you are basically challenging the combined gradation list.
Gradation list, lordship. Earlier, a gradation list was prepared, page 80, lordship. My place is 11 on the basis of seniority.
Hmm.
Now, again, earlier also it is combined gradation list. Now again, combined gradation list will be prepared.
So why you are challenging it on what?
It was on the basis of date of birth.
Hmm.
And I have put down to 48. Earlier I was 11. I put down to 48, and all my juniors or.
Yes, but that is the problem. You have to implement your juniors. You have not done it.
Yes, lordship.
How your prayer can be allowed without hearing it?
I have challenged that they are the process of adopted by the authority.
After a long journey, your whole matter will come to a zero. Someday somebody will take this plea that you have not implemented.
Lordship.
And you can't even add them without a pleading.
Yes.
Without proper pleading, you cannot even add them. If you add them, they'll come and say there is no allegation against us. So it is either a dismissal on withdrawal with liberty today or a dismissal on
Liberty,
merit
Lordship.
some other day.
Lordship,
Choose which do you want.
with the
Mr. L. P.
liberty.
Contestant and counsel for the petitioner seek leave of this court to withdraw this writ petition with liberty to file afresh after rectifying the defects in constitution of the writ petition. Mr. S. Datta, learned standing counsel PNRD Assam is present and does not have any objection with the prayer result. Writ petition stands disposed of
Obliged.
on withdrawal with liberty as paid for.
Hello. Lordship.
My lord, a broad issue involved here is that these persons, my lord, they were retired from the Assam Rifles by invoking provisions of Rule 48 of the CCS rules. There have been subsequent judgments, my lord, which have held that Rule 48 cannot be used to retire a person on medical grounds, and Rule 26 of the Assam Rifles is to be used, my lord. But then the difficulty in our case is that, my lord, we were not a party in the earlier writ petitions. But since the law has been laid down earlier, whether if the earlier judgments, my lord, operates in rem, my lord, then the principle is settled, my lord, we may be also covered. And if these are to be held, earlier judgments are to be held in person, my lord, we are not covered.
Is it a part of the record?
My lord, Annexure 2 and Annexure 6, my lord. There is one judgment from our Guwahati High
Give
Court,
me the page number, please.
my lord. Annexure 2 is page number 74 onwards.
So is this case covered by under this judgment 12/2/2021?
In this regard, my lord, similar cases pending before this honorable court for instruction is necessary. At a
What is the similar case number?
my lord, at page 129, my lord.
129. Annexure 7, my lord.
Annexure
I have
7,
also
129,
enclosed,
my
my
lord.
And where is the order of retirement, interim order?
lord. Annexure 1 series, my lord. There is a bunch of papers, my lord, in respect of all the other persons. Annexure 1 series, my lord.
Pathak, counsel for the petitioner by invoking the provisions of Rule 48 of the Central Civil Service bracket pension rules bracket close 1978. The petitioners have been retired from service by treating them in the low medical category bracket LMC. Mr. Pathak submits that the law is well settled that the provisions of Rule 48 cannot be invoked for sending employees on retirement on the ground of LMC. Full stop. According to Mr. Pathak, the case of the petitioner is covered under the judgment and order dated 12/2/2021 passed by this court in a similar writ petition bearing number WPC 1421 of 2017. Mr. A.K. Datta, Planet CGC, on the other hand, submits that similar matters are pending before this court and therefore he be granted some time to obtain instruction in the matter. NOM 6 weeks since Mr. Datta has appeared and accepted notice on behalf of all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel. Requisite in numbers so as to enable him to obtain instruction. Let this writ petition be listed again along with WPC number 1130 public 2022, which is pending before this court, which is stated to be analogous to the present writ petition.
1130 and 2368 of 2020.
And 2368 of 2021.
22, my lord.
2020.
Definitely.
May I please, Lordship? And the petitioner's claim for compassionate appointment has been rejected, my lord, due to lack of vacancy, want of vacancy, my lord. And therefore, petitioner is approaching this honorable court for a direction.
So what to do if there is no vacancy?
If there is no vacancy, as per clause 15 of the office memorandum, my lord, it can be taken into consideration in respect of other department, my lord.
But that clause which is in harping, man, there's a rider, man, there has to be a waiting list. In the case of a petition, it is not a waiting list. Lordship will go through once that clause, madam, at page 43.
You want to obtain instruction or?
I have to obtain instructions, madam, because there's a rider, madam, that there has to be a waiting
Or
list.
Mr. B. Professor and counsel for the petitioner agree by rejection of his appeal for appointment on compassionate ground. The petitioner has approached this court, compassionate ground on the uh,
Want
ground
of
that
vacancy.
vacancies are not available in the department. The petitioner has approached this court inter alia contending that the case of the petitioner was not considered against vacancies in other departments as per clause 15 of the government office memorandum dated 01/06/2015. Mr. B. Gogoi Leonard SC Forest Department.
PH, madam, this
PH,
PH.
Assam, as well as Mr. S. Purva Leonard Government Advocate Assam appearing for the official respondent have prayed for time to obtain instruction. First, issue notice of motion returnable in 6 weeks. Since Mr. Ms. Borua has accepted notice for respond number. No, since Mr. Gogoi has appeared and accepted notice for respond numbers. Can you tell who you are appearing for?
Madam, 1, 4, 5, 6, madam.
1, 4, 5, and 6, and Ms. Borua for respond numbers 2 and 3. 2 or 3. Service complete, extra copies acceptance.
Oblige, lord.
Item 16.
May it pleases your lordship. Lordship, petitioner herein was dismissed from service without giving opportunity to defend his lordship. While drawing up the disciplinary proceeding, lordship, neither any statement of charge nor any statement of allegation was communicated to the petitioner, lordship. And he was totally unaware about the disciplinary proceeding, lordship.
You'll accept, you'll issue notice now.
Lordship. An appeal was also preferred, lordship.
All right, had Mr. M. Zaman and counsel for the petitioner. Assailing the order dated 21/11/2022, by means of which the petitioner was dismissed from service as constable under the Assam Police Battalion. The instant writ petition has been filed inter alia contending that the order of dismissal is based on an inquiry proceeding conducted behind the back of the petitioner and without giving an opportunity of being heard to him. Mr. Ms. S. Borua, Learned Government Advocate Assam, prays for some time to obtain instruction. Issue notice of motion returnable in 6 weeks. Since Ms. Borua has appeared and accepted notice for all the respondents, the formal notice, extra copies, the Learned Department Council to file affidavit and also produce the records.
Oblige, lordship.
Item 17.
There is an order which has been passed by the Office of the Senior Government Advocate at page 61. The petitioner before your lordship, junior assistant administrative, grade 3 employee, who is working in the Office of the Senior Government Advocate, attached to the PP office, man. And there is a charge which was leveled against him. So cause was issued, and thereafter, at page 61, on 3/4/2021. At 63 my lord. He worked for 24 years of service in the High Court. At page 63. Stands compulsory retired from service with immediate effect. At page 63. Last 3 lines, my lord. Junior administrative assistant, office of so and so, stands compulsory retired. Now there is a provision for appeal. We prefer an appeal.
before response number 2, my lord.
Hmm.
LR. Now that appeal 2021 we have filed, my lord, as on date has not been disposed of. That's the whole difficulty. I'm not saying that your lordship will adjudicate this matter. Only for this we have come up before this court. And an additional affidavit was filed. Somewhere it was not annexed. So in the appeal, my lord, we appeal memo is there. We have filed.
What has happened to the appeal referred by the petitioner?
Lordship, at this stage, I have no instruction regarding the position of that appeal. If the lordship may, I may submit the, I am.
You find out, we'll have it
Yes,
next. week.
Lordship,
Next
lordship.
week,
lordship.
All right.
Next week, my lord. Lordship,
Lord,
prepare the
Mr. D.
motion, my lord.
Yes, yes.
Yes.
Lord Mr. D. Das, Leonard Senior Counsel appearing for the petitioner who submits that aggrieved by the order of compulsory retirement from service passed on 3/4/2021. The petitioner had preferred an appeal before the appellate authority, that is the legal remembrance of state of Assam. On
We filed appeal on 25/5/2021.
on 25/5/2021. But no action has been taken in the appeal till today, as a result of which the petitioner has been compelled to approach this court by filing the present writ petition. Mr. J.K. Goswami, learned additional senior government advocate Assam, seeks 1 week's time to obtain instruction and appraise this court as to what action has been taken by the concerned appellate authority in the matter. Full stop. One extra copy of the writ petition be furnished to Mr. Goswami. Registered to list this case for motion again next. That is 19th of
19.
Can it
19th
be
of May.
17, lordship?
Huh?
Can it be
17,
17?
a bit of difficulties and let it be on 19, my lord.
Why 19? What is the problem?
I have some. Lordship.
Whoever is there. will
Anyway,
be
lordship. Anyway.
19 for motion.
Deeply obliged.
It is made clear that pendency of this writ petition will not be a bar for the authorities to take appropriate action in the matter as per law.
Deeply. May it please the Lord. My lord, the petitioner before your lordship is aggrieved by the punishment of compulsory retirement imposed on him. We are challenging, he is challenging that order. And my lord, an appeal department is an employee of the bank. An appeal was also filed, but they have not decided the appeal.
What has happened to the
Your
appeal?
lordship, I have not been served with a copy of the writ.
My lord, bank, they don't have a standing counsel. So normally notice goes to the bank. That is why I could not. If you want, I
This
can
is
give
which bank?
Indian
Indian
bank.
Bank, your lordship.
Will you appear for the Indian bank?
Yes, sir.
Huh?
Yes, sir.
The lordship
Can you
may-
file a
No,
wakalatnama?
your lordship, today we will file it.
All right,
My lord, may
then I'm fixing it on 19th, not 19th, 22nd. You tell us what has happened to the appeal.
Yes, your lordship.
Heard Mr. S. Chakraborty, learned counsel for the writ petitioner. Peruse the averments made in the writ petition. Mr. M. Sharma, learned counsel, submits that he has instructions to appear in this matter on behalf of the bank and be granted some time to obtain instruction. Be that as it may, considering the grievance of the petitioner that his appeal preferred against the order of compulsory retirement from service has not yet been considered by the authorities. Mr. Sharma to seek instruction and appraise this court in the matter on the next date fixed. Let this writ petition be listed again for motion on 22nd of May 2023. One extra copy of the writ petition be furnished to Mr. Sharma
Highly obliged.
during the course of the register to list this case again by reflecting the name of Mr. M. Sharma in the cause list.
May please, your lordship. Lordship matter relates to appointment selection of the Gam Pradhan in respect of Morrigaon district. We have preferred an appeal before the appellate authority, lordship. That is at page 51, lordship.
So let the appeal be disposed of.
Yeah, lordship. We may dispose at that line.
Mr. M.K. Sharma, Mr. M.K. Bora, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the response number
Lordship 3 to 6, lordship.
3 to 6. Mr. S. Dattan and SC Revenue Department Assam has appeared for response numbers
1 and 2.
1 and 2. Stop. The writ petitioner hearing is is challenging the selection of the respondent number 7 for appointment in the post of Gaon Pradhan in respect of
Jajuri
Jajuri
Bormanipur Gaon.
Jajuri Bor Manipur Gaon and the district of Morigaon, Assam. Internally on the ground that the petitioner does not meet the eligibility criteria as envisaged in clause 162 bracket A bracket close of the executive instructions framed under Assam Land and Revenue Regulation 1886. Mr. Bora submits that the petitioner has preferred an appeal before the respondent number 6 under clause 162 bracket C of the executive instructions, but no action has been taken in the appeal to today. Hence the read picture. Mr. S. Datta, Learned SC Revenue, and Mr. J.K. Goswami, Learned Government Advocate Assam, have submitted in tandem that since the petitioner has already referred an appeal, this read petition be disposed of with a direction upon the respondent number 6 to hear and dispose of the appeal in a time-bound manner. Mr. Bora has also agreed to such a recourse. In view of the above, without expressing any opinion on the merit of the case, this read petition stands disposed of with a direction upon the respondent number 6 to dispose of the appeal referred by the petitioner as expeditiously as possible, but not later than 60 days from the date of receipt of a certified copy of this order. Full stop.
Interim Lordship, in the
What-
interim Lordship.
Out of the prayer of interim relief, it is hereby
Lordship,
provided that if no order of appointment has in the meantime been issued in favor of respondent number 7, the same shall not be done without verifying the allegations brought against him by the writ petitioner.
Obliged.
Item 20.
May it please, your Lordship, petitioner praying for compassionate appointment, Lordship. Lordship, petitioner father died, Lordship, 4/8/2007, Lordship.
4/8/2000.
7, Lordship.
Oh,
Lordship,
2000.
he is in, still in, okay, honorary basis, Lordship. He was appointed, Lordship.
we'll close these matters after notice. You obtain instruction.
Yes, Lord.
Heard, Mr.
He was rejected by SLC because at the time of application, he was not completed 18 years. He below 18 years.
5 months short.
He was below 18 years. Therefore, he was rejected.
What can be done?
Lordship, OM was Lordship, 15, and my case was Lordship, 2007, Lordship. The Lordship judgment, Lordship,
All right, you obtain instruction. Heard, Mr. A. Sharma, Learned Counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by rejection of his application for appointment on compassionate ground. Full stop. According to the petitioner's counsel, the wrong office memorandum has been applied by the authorities to reject his claim on the ground of delay. Full stop. Ms. S. Borwa, Learned Government Advocate Assam, prays for some time to obtain instruction in the matter. NOM 6 weeks since Ms. Borwa has appeared and accepted notice for respondent numbers 1, 4, and 5, and Mr. S. Datta, Learned SC Revenue for respondent numbers 2 and 3.
I'm 2 and 3 and 6.
2, 3, and 6. Service of notice is deemed to be completed in this case. Extra copies of writ petition be furnished to the Learned Departmental Council, requisite in numbers, so as to enable them to obtain instruction, facilitating disposal of the writ petition at this stage of admission hearing.
Item 21.
May I please? Ma'am, the petitioners here of in the second course of litigation matter, they have approached this honorable earlier to 4 individual petitions for claiming promotion to the post of sub inspector of police, my lord, and their juniors have been promoted
We'll issue notice, that's all. Heard Mr. B. Procrastinary counsel for the petitioner. The claim of the petitioner pertains to. Now, this matter pertains to.
1 to
claim
5.
As regards promotion. I have perused the statements made in the writ petition. Issue notice of motion returnable in 8 weeks. Since Mr. T.C. Chutial and additional senior government advocate Assam has appeared and accepted notice. Petitioners.
1, 2, 3, 4, and 5. 1 to 5.
1 to 5. And no formal notice is required to be sent to the said respondents. However, extra copies of the writ petition be furnished to the learned department counsel so as to enable them to obtain instruction, enable him to obtain instruction in the matter. Petitioner to take steps for service of notice upon the remaining respondents. The question of maintainability of this writ petition on the ground of misjoinder of parties is kept open and shall be gone into at the stage of admission hearing. Where have we joined all this?
They have, my
Promotion.
lord, they have separately, they have filed the cases, my lord. And now what happened in this earlier round, they have filed the reply, my lord, opposition.
Why have we joined all of them in the writ petition? If these are individual claims, somebody may be promoted, somebody may not be.
They have their,
Seek some lesson from Mr. Tiwari. You will tell you. All right.
Yeah, please, your lordship. My lord, petitioner is presently serving as assistant commandant, CRPF, my lord. And he was promoted in the year 2016 as assistant commandant ministerial CRPF, presently posted at Khotkoti Karibalam. Now, you're not after promotion, my lord, the probation period is 2 years. So, my lord, when he was promoted, he was under the medical category of SAFE 1. It is a mandatory, my lord. SAFE 1 is a mandatory condition to promote. So, when he was promoted, he was under the SAFE 1 category. So, during probation, your honor, the petitioner was detected diabetes and hypertension. So, he come under SAFE 2. And during that probation, again come under SAFE 3. So, during this probation, your honor, there is a provision for annual medical health checkup examinations of the forces. So in the annual medical examination, your honor, he detected that yes, his condition is now normal. So he applied for, my lord, premature medical board review before the authority. Accordingly, my lord, authority forwarded the same to the headquarters, and the headquarters, my lord, head office, my lord, approved for the premature medical board examination. Accordingly, he appeared, and after appearing, my lord, the examination was done, and he has been recommended as SAFE 1. Now he is under SAFE 1. So, you know, after declaring the SAFE 1, suddenly, my lord, the authority not passed the impugn order, reverting his post from assistant commandant to, my lord, Subedar Major, saying that in 2021, his medical condition was under SAFE 3.
He was in probation.
My lord.
So what can be done? Probation is absolute discretion.
My lord, that is true. But here, my lord, as per the standing order, there is a provision.
Where is the order?
My lord. My lord, page 92. That is a type copy, my lord.
We'll issue notice beyond.
My lord, lordship, may kindly consider, my lord, I will show you, my lord, 2-3 documents, my lordship. Lordship, may kindly see page 84. Well, this is the my lord, departmental standing order regarding consideration of those candidates, those employee come under SAFE 2, but they are under drug control.
Mr. Sinha,
My lord.
your client was on probation.
My lord.
Even if everything is absolutely right, even then they can discharge him. If
True,
the
my
order is not stigmatic, you can't do anything about
No,
it.
my lord, what happened, my lord? Why
You are right,
yes.
but still they can discharge you.
Discharge, my lord, but my prayer is, my lord, in a similar situated case, my lord, even before promotion, my lord, the person, the candidate has to have under SAFE 1. In one instance, my lord, one person, the same rank.
Mr. Sinha, you have not followed what I am saying. Your arguments are all correct. He was in SAFE 1.
My lord.
Still they can discharge him because he was in probation. Meet that argument.
My lord, in that case, my lord, the authority has the right, given the condition, to, my lord, review The review condition is there. It is not that, my lord, once he come under.
So you make an application for review? Have you made an application?
My lord, no, already, my lord, for review, my lord, I have already applied for this medical board review. They approve it, my lord. After approval, my lord, I appear before the authority.
No, against this order 17 April 2023.
My lord, this order has been passed when my lord, I am in earned leave, my lord. Still, I am in earned leave.
Well, Mr. Sinha, you see, you don't appear to be conversant with the law on probation period.
My lord,
I will issue a notice, but that will cause more prejudice to your client. It is only the departmental authorities who can change this view. The court
lord,
cannot say.
kindly consider this statement of Annex 13, my lord, page 99. My
You're
lord,
not understanding what is coming.
my
from
lord,
the
I
court again and
understand.
again.
Lordship may kindly see this standing order.
The court cannot sit in appeal over the decision of the authorities. They can only review, the court can only review the process. And the process, the law is that if it is not stigmatic, they can discharge your client and revert him in the probation period without any reason. This is completely subjective.
My lord, it will be a stigmatic order, my lord, because already I have serving more than 34 years.
All right, heard Mr. K. Sinha, Learned Counsel for the petitioner, assailing the order dated 17/4/2023, passed by the respondent. Respondent number?
My lord, all the respondent, my lord.
All the respondents.
All respondents are
The order has
passed.
been passed, order, respondent number 2, my lord.
Respondent number 2. Sorry. Reverting the petitioner from the post of assistant
Director General.
commander
Director General.
to the post of Subedar Major, is it?
Yes, ma'am.
During the period of probation on the ground that he was on the apparent ground of not fulfilling the medical requirements, the instant writ petition has been filed. Full stop. Mr. Sinha submits that the authorities have not considered the report of the medical board in the correct perspective before issuing the impugned order. Full stop. Ms. R. Devi, learned, the CGC appearing for the respondents prays for some time to obtain instruction in the matter. To notice of motion returnable in 6 weeks. Since Ms. Devi has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the learned departmental counsel so as to enable her to obtain instruction in the matter.
My lord, my only limited prayer, my lord.
Lordship, during the entire probationary period, he was in set.
No, there will be no stay. Stay.
My lord, not stay, my lord, but this order, my lord, the outcome, this order, my lord, outcome of the writ petition, my lord.
Even the probationary period was extended.
Obviously,
and
what
he could
else
not-
is there? The order challenge will always be outcome of the writ petition. Is it
Yes.
something to be written down?
My lord.
No.
But you have caused enormous damage to your client today by not understanding the law.
My lord, I
You should have
understand.
gone to the appellate authority and the court could have asked them to decide your appeal in a time-bound manner with an objective, with the objective standards. You have not read those judgments probably on, anyway, next matter.
Problem.
Obliged.
Lord, the pleadings are complete. Since the dispute is over the fixation of interstate seniority in the cadre of sub-inspector food and service applies, propriety demands I should not pray for disposal at the admission stage. I leave it to my lord.
You are appearing for?
4, 5, and 8.
Okay. Heard Mr. P.K. Tiwari, learned senior counsel listed by Mr. A.R. Gogoi, learned counsel for the writ petitioner. Also heard Mr. P.C. Chutia, learned government advocate Assam, representing the respond numbers 1 to 3. Mr. M. Sharma, learned counsel has appeared for respond numbers 4, 5, and 6. It is submitted at the bar that the pleadings are complete and the matter can now be taken up for final disposal. Since the controversy involved in this writ petition pertains to
Fixation of interstate seniority in the cadre of sub-inspector food and service
fixation of
supplies.
interstate seniority in the cadre of food and
Sub-inspector food and service supplies.
Sub-Inspector Food and Civil Service, the matter would call for a full-length hearing. As such, admit the writ petition. Since the parties are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel. No, sorry, that's not required. I registered to list the matter on 20th of June 2023 for hearing as a fixed matter.
4, 5,
4, 5, and 8.
4, 5, and 8.
Who is appearing for 6?
Other son of counsel.
None is appeared for respond number 6.
Wait, please, Lordship. Well, before submitting, my lord, I may submit, my lord, the similar matter has already been disposed of, my lord, by various orders, my lord.
OBC.
My case is also my totally covered by this, my lord. Selection and.
Same thing.
Yes, my lord.
How many read petitioners?
My lord, seven, total, 8 petitioners,
All of their cases are covered.
my lord.
Same order, Mr. PJ Saika, learned counsel for the petitioner, Mr. SSR, learned additional, learned CGC appearing for the respondent, and Baki same order, all petitioners, huh? Those
8 petitioners.
Govinda Sharma has taken one order, disposed of.
Well, in this case, my lord, once it was disposed of, my lord, but my learned failed, my lord,
Once it was disposed of.
disposed of, my lord, and also file review. Review was also dismissed by,
Hmm.
they file review and division bench also almost, my lord, dismissed and but
Almost
again,
dismissed,
almost dismissed.
not 100%.
Not 100% because
How much? 90% dismiss.
90%, my lord.
Give me a percentage, how much, what?
No, my lord, that because my lord, honorable division bench held observed that my lord matter has not been heard by the honorable single judge, my lord, in respect of them. But 13 occasion it is mentioned, they did not appear. In the review also, review petition dismissed by the honorable single judge also.
Hmm.
It was disposed of 21/10/22 itself. Thereafter again.
What to do now?
The lordship may, in another date, lordship may fix and
Another
dispose of this matter.
Where is the order of the Writ Appellate Court?
Appellate court, I have, it is not along with me at present, my lord. But the honorable division bench held that, my lord, matter to be heard by the honorable single judge again and
Where is the
5,000
division
cost.
bench order? You
Lord,
prefer the writ appeal.
Today, my lord, I could not bring lordship.
5,000 cost also given.
That may be fixed, lordship.
When will it be convenient for you to give the order?
That my lordship.
As paid for learned counsel for both the sides, this matter stands adjourned for 4 weeks. This case again on a non-miscellaneous day for admission.
Otherwise, my lord, she is my lord, holding the post, my lord, getting the benefit. But
And for one
All right.
Actually, you write, Mr. H.P. Das for petitioner, Mr. Listen, what is his name? M.H. Ahmed for, you are for respond number
I'm for respondent 6, lordship.
and Ms. S. Borua
1 to 5, Lord.
for 1 to 5. Yes, sir, that will be submitted to the bar.
Lordship covered matter, lordship.
What is
May I
the
please, your
matter?
lordship. So this is covered matter, lordship. Petitioners are engaged by the hospital management committee, lordship. The similar matter was lordship disposed of, lordship.
Lordship, there was a writ petition preferred by some set of petitioner being WPC 7711 of 2016, lordship.
Hmm.
It was dismissed by the single bench, lordship. Then they preferred an appeal, lordship.
Hmm.
The appeal, lordship, the division bench remanded back the same to the single bench, and the single bench, lordship, disposed of the matters on lordship 10/11/2022, lordship. This was the order.
Where is the order?
And subsequently, lordship, this writ petition was disposed of in view of this order, lordship. Paragraph 21.
Paragraph 21 to 23 is the relevant portion, lordship.
Take down hard, Mr. Your name, please.
S. Ali, lordship.
S. Ali, learned counsel for the writ petitioners. Also heard Mr. D. Upamanyu, Learned Standing Council, Health Department, Assam, appearing for the respondent numbers.
All the respondents. Lordship.
Appearing for all the respondents. First of these petitioners herein were all engaged as casual workers by the concerned hospital management committee oblique society operating under the official respondents, and they claim to have been working for more than 15 years. First up, aggrieved by non-consideration of the prayer made by the petitioners for payment of minimum pay scale, they have approached this court by filing the instant writ petition. First up, Mr. Ali submits that the case of the petitioners is covered under the judgment and order dated 10/11/2022, passed in WPC number 7711/2016, and therefore the present writ petition be disposed of in terms of the aforesaid judgment. Mr. Upamanyu has also fairly submitted that the petitioner's case would be covered under the aforesaid judgment of the learned single judge, passed in WPC number 7711/2016, as well as the subsequent order dated 29/3/2023, passed in WPC number 5147/2022. First up, from a perusal of the judgment dated 10/11/2022, I find that the learned single judge, while dealing with a similar prayer made by as many as 29 writ petitioners serving under Lakhimpur Civil Hospital and Dhemaji Civil Hospital, have disposed of the writ petition by making the following observations in paragraph 21, 22, and 23. Quoted. First up, since there is no dispute that the petitioner's case would also come under the aforesaid judgment, this writ petition also stands disposed of in the light of the judgment and order dated 10/11/2022, as noted above.
Highly obliged. Highly obliged.
Item 26.
May it please the lordship, the petitioners, your lordship, had applied for the post of clerk cum computer operator in Oil India Limited. Your lordship may kindly peruse page 18, the advertisement. And then page 19, your lordship. 3.
So only one thing, if I may just submit before my learned friend says, already the appointments have been made, but they have not been made a party in this proceeding. So since our recruitment process is under challenge, it will be prudent on their part probably to implead those people who have already been appointed.
What is their prayer?
Their prayer basically is regarding the computer test, they are asking for some normalization. According to them, the process in which the computer test has been conducted is not to their liking, and they are saying that it has to be normalized. But in my humble submission, they have participated in the.
No, are they seeking any relief that they should be appointed or something like that?
No, your
Yes,
lordship.
You don't want any appointment.
Their case is
No,
for
no,
that.
your lordship, yes.
Then,
Ultimately, yes.
unless you make them party, this is.
No, we are.
The case is basically for appointment, and they are saying that they are prejudiced by the way the computer test has been
Mr.
conducted.
Deori, please understand the question and give a short and simple and sweet reply.
Yes, sir.
Are you seeking setting aside of the appointment made to the other persons, and in their place you should be appointed?
No, your lordship, when we had filed the petition, they were not appointed.
On the
Don't-
prayer of Mr. I mean, you are not answering the question. Are you seeking that relief or not?
Yes, your lordship, definitely.
That cannot be done unless you make them party. I'll decide the matter just now if you want to argue. How can we set aside somebody's appointment without hearing them? These are all fundamental principles of law.
True, I understand, your lordship.
Then
But when we had filed this writ petition, your lordship, when we had filed this writ
maybe
petition.
now you have to implement them.
If your lordship allows.
No, no, otherwise you argue, we'll decide it.
This
You are saying that their appointments can be set aside without hearing them. Is that?
No,
you
no,
are-
no, 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 that is not my point. Your
If you say that you are not seeking
No,
to
no.
disturb their appointment, then you are good.
No, no,
Then there is no problem.
definitely, I will make them a party, your lordship. I will be granted sometime.
You have to, otherwise if they are not heard, how can their appointments be set aside? Mr. T. Dury, learned counsel for the petitioner, submits that although no appointments were made in favor of any private person at the time of filing the writ petition, yet due to absence of any interim order, in this case, appointments have been made in the meantime. As such, considering the nature of relief sought for by the petitioners, which would entail interference with the appointment of the selected persons, he be granted 4 weeks time to implement the appointees. And you also have to amend your relief.
Yes, yes, your lordship.
By making proper amendments to the writ petition. Mr. A. Sharma, learned SC, Oil India Limited is present and does not have any objection if the prayer is allowed.
You will be directed to provide me with the list of the candidates, your lordship. I do not have this one.
Since the petitioner's counsel has submitted that he doesn't have the names and particulars of the appointed candidates, the learned SC Oil to furnish list of such candidates to the petitioner's counsel within 10 days from today by obtaining written acknowledgement.
I'm deeply obliged.
But you will have to also amend the pleading.
Yes, yes, definitely.
Or maybe file a subsequent writ petition.
Lordship will give us 2 weeks time, lordship. Lordship will give us 2 weeks time.
2 weeks time.
I will be allowed to amend the writ petition, your lordship. Amend the writ petition.
You examine and say what you want to do. You are almost asking for advice from the court what to do. Huh?
Sorry.
Don't ask for legal advice. Will not give you. Yes. Just 5 minutes, I'll come back.
Matter.
My lord, order impugned is at page 28, my lord, where the petitioner who is working in the with the National Insurance Company was transferred from Silchar to Guwahati. Page 28 and 7 is impugned here, my lord.
Page 28.
Page 28.
What is the ground on which you are
My
challenging?
lord, the ground on which, my lord, we have impugned this order is that, my lord, it is punitive in nature. And that, my lord, no opportunity, they have said that there is a finding committee.
Where is the judgment which says punitive transfer is not permissible?
In fact, my lord, I could not lay my hands to those judgments. Some 66 judgments are there. And lordship is aware, my lord, any transfer which is in public interest or for some administrative exigency, courts will generally not interfere. But here is a case, my lord, where they are saying that they are indiscipline committed by her. If there is
That's right, but where is the judgment? I will pass a judgment right now. You're not prepared.
that judgment is not there.
Then we'll take it that law is not there. Then you will have to labor her.
My lord, this is the settled principle of law that if it is a punishment, at least, my lord, the opportunity should be provided to the employee that she can defend herself. Now here, my lord, they have enclosed these documents along with their affidavit in opposition, but that this report of the committee, what they are saying on the basis of which this order has been passed, that was never furnished to the petitioner, my lord. It is only before this court, my lord.
Where is the report?
Report they have enclosed along with their IA, my lord.
You should have come up with at least one judgment on that.
Some recent judgments we are looking for. Some 66 judgments are there. 66 and
No, you could have come up with only one. Difficult, no?
The report is at page 36, my lord. Of their
What is this report?
My lord, that says, my lord, they have conducted some inquiry And on the basis of this inquiry, my lord, they have decided, my lord, 39 is the report. Page 40, as instructed by the competent authority, the undersigned accompanied by Shri so-and-so Sejjar on 14 February 22 on fact-finding mission pertaining to the allegation of workplace harassment made by Srimati Debashri Chaudhary by mail addressed to chief manager with copies marked as so-and-so. The undersigned respectfully accordingly we reached the concerned Sejjar division on 14/2 straightway started with the job at hand. However, before proceeding with the matter, it would be in order to discuss chronology of the events based on available documents at hand. 18/11/21 disciplinary letter issued to, there was, my lord, if I may pause for a moment here, my lord, she had sustained some burn injuries, severe burn injuries for which she was hospitalized and she availed some leave. For that, my lord, she was giving her representations for regularization of that leave period. And then she had also suffered COVID during the first wave of COVID. For that also, she had availed some leave. And for that, she had from time to time, she was sending those representation before the authorities for regularization of those leave, my lord. I have enclosed those, my lord, in annexure 1, 2, and 3, my lord. So disciplinary letter issued by so-and-so, which was
Mr. Das, let them hear him and then pass an order. But we'll set aside this order. Indiscipline word cannot be used. You can argue for a whole day, but this will be the order of the court. You know the law. She is not prepared, but I know the law.
I've seen it. That creates the difficulty. Otherwise, well, it was okay. Well, let him file a representation to the authority and the authority will hear.
So we'll set aside the order of transfer. And they will be at liberty to take fresh view in the matter after giving him an opportunity. But if they say that there is misconduct of indiscipline.
No, in that case, my lord, the regular department inquiry has to be done.
So you advise them accordingly.
But the district inquiry can be done.
That's right, but the order says indiscipline. That word in the order is good enough. You tell your clients the mistake they have made. What to do now? Heard Ms. P. Chakraborty, learned counsel appearing for the petitioner. Also heard Mr. B.C. Das, learned senior counsel assisted by Mr.
S.H.
Learned counsel appearing for all the respondents.
All
good. In this writ petition, the transfer order dated 28/4/2022 issued in respect of the writ petitioner, transferring her from Silchar Divisional Office and posting her at Guwahati Regional Office of the National Insurance Company Limited has been put under challenge on the ground that the order is contending that it is a clear case of punitive transfer. First up, it appears that there was complaint of harassment in the workplace brought out against the petitioner by some employee, whereafter the authorities had conducted joint.
That report your authority will find.
Yes, at page 40, 39/40.
No, that is against the complaint made by the co-worker.
Where is the report against the petitioner?
39/43, my lord. Against the co-worker. That is the order.
No, where is the report against the petitioner?
That is, my lord, at page 44. About sexual harassment and all that.
Petitioner is a lady.
Lady.
So complaint of sexual harassment against her.
No.
She alleged.
She alleged.
She made a.
She alleged.
And after inquiry, she was transferred.
No. That inquiry was time-barred. That is the finding of the court. Simultaneously, there was a complaint from the co-workers.
Against her.
Against her.
So that is what I am saying.
That is right.
Page 39 is the report.
39
is the report.
It appears that the co-workers of the petitioner had made some complaint against her in respect of harassment in workplace, pursuant whereto a joint fact-finding exercise was conducted, whereafter a report was also submitted by the committee on
Page 43, Roshan. Conference report.
Yes, page 43.
on a report was also submitted on 4/3/2022. Some adverse comments, adverse entries against the petitioner.
Yes.
Yes.
my lord.
Where
Page-
is
That
Page
she is
43.
spoiling the work environment culture of the office, which has demoralizing effect on the
it was
staff.
observed that the petitioner is spoiling the work environment oblique culture of the office by demoralizing other staff and officers. First up, based on such report of the fact-finding committee, the impugned transfer order has been issued. The operative part of the transfer order is reproduced herein below for ready reference. Page 28 of the writ petition, double tick to double tick. Full stop. From a plain reading of the transfer order, it is apparent that the same is the outcome of the fact-finding report, wherein it was held that the petitioner is guilty of misconduct. Accordingly, an observation has also been made in the transfer order dated 28/4/2022, alleging that the petitioner has been alleging that accordingly, an observation has also been made in the impugned order of transfer dated 28/4/2022. Full stop. However, the learned counsel for the petitioner submits that that the petitioner was not given an opportunity of being heard on the inquiry report dated 4/3/2022. That apart, submits Ms. Chakravarti, the order of transfer on the face of it is punitive. Full stop. Mr. Das, then as senior counsel for the respondents, has fairly submitted that the order dated 28/4/2022 reflects that the same was issued on the basis of the report of indiscipline on the part of the petitioner, and to that extent, she ought to have been heard in the matter. First of, however, the said observation, according to Mr. Das, cannot come in the way of the authorities in taking appropriate action in the matter by following the due process. First of, a reading of the order dated 28/4/2022 leaves no room for doubt that the same casts an aspersion upon the petitioner of being guilty of indiscipline, guilty of misconduct in the form of indiscipline in discharge of her duty. First of, therefore, the order is clearly a punitive order of transfer. Therefore, it is a punitive transfer. Therefore, it is clear that it was a punitive transfer, which is not permissible in the eye of law. First of, for the reasons stated herein above, the order dated so and so is hereby set aside. The respondents would, however, be at liberty to give an opportunity of being heard to the petitioner and thereafter pass fresh orders in the matter by following the due process of law. Writ petition stands closed. In view of the order so and so, I stand disposal.
May I please, your lordship? My lord, matter pertains to my lord promotion from Anganabadi helper to Anganabadi worker, my lord. You know, there is a guideline for promotion, my lord, and as per that, my lord, guideline, my lord, it is strictly, my lord, the promotion should be strictly on basis of, my lord, the seniority. Come merits, my lord, that is on basis of, my lord, mark obtained in class 9. So here in the petitioner is senior.
Why have you implicated the private respondent?
My lord, she has been appointed, my lord, in my place.
I'm senior to her, my lord, and my lord, the promotion has been, my lord, my lord, advertisement for promotion has been, my lord, published for the same center wherein, my lord, I have been rendering my services since last almost 14 years, my lord. So as per the guideline.
We have filed our affidavit, Lordship.
What about private respondent?
And a private respondent has passed HSLC.
No, who is appearing for the private respondent?
Private respondent, my lord.
Yeah, what do you have to say?
My lord.
Yes.
His client was appointed as Anganwadi helper.
Yes.
As per the guidelines, promotion is to be given to Anganwadi worker by following the principle of seniority.
Yes.
Instead of doing this, if respondent number 5 has been appointed as Anganwadi worker.
Yes.
That is his case.
Yes.
So is it a post to be filled up by direct recruitment or by promotion?
It is direct recruitment. Lordship.
Where is it?
It is appointed promotion on and merit, on the basis of merit.
Where does one find that?
Selection, advertisement.
You are not prepared. You cannot prepare and argue the matter now. That's not going to happen. Are you prepared to argue the case?
No, it's
Why?
sometime.
Why not?
Kindly come to page 13 of writ petition, Lordship. And
Page 13 of writ petition.
yes, here Director of Social Welfare issued a letter to CDPO, Lordship. And on the basis of this letter,
this is upgradation, not promotion.
Upgradation.
advertise them calling for application from the eligible Anganwadi helpers with prior permission of the Director of Social Welfare.
Where are you reading from?
Page number 13. May I read?
Yes.
With reference to the above subject, I would like to enclose here with the government notification so and so dated so and so for upgradation of eligible Anganwadi helper to Anganwadi worker. In this regard, I would like to inform you that the paras 10 has laid that it shall be the responsibility of the CDPO to determine the vacancies and advertise them, calling for application from the eligible Anganwadi helpers with prior permission of the Director of Social Welfare.
Right. So it was required to be done by calling for application for Anganwadi helpers. Yeah,
And
how the respond number 5 has been appointed?
both are working as Anganwadi worker on the same center. And
What same center? Different center.
same area, revenue village area. And the respondent number 5 pass HSLC on third division, and petitioner passed the HSLC on compartmental basis.
Third division and compartmental.
Yes, she has first
Whom have
time,
you chosen? Who
and
did
on
you
the
choose?
basis of that, they have selected.
Keen competition, third division and compartmental. Very tough competition. Yes. Then what happened?
On the basis of that, they have selected respondent number 5. We have.
My lord, here matriculation is not relevant, my lord. Here, my lord,
HSLC.
it has been, my lord, stated in the advertisement also, my lord. That is the
Merit
mark
is-
obtained in class 9, my lord. In the guideline, is it, my lord, itself.
Where is the record of selection? You have the record.
Now I have not the record. I have to.
Let us see how the selection has been made. We produce the record after 4 weeks. Heard Mr. B.K. Dalani, Counsel for the Petition, also heard Ms. S. Burwal, Government Advocate Assam appearing for the respondent numbers 1 to 4. None has appeared for respondent number 5. Having heard the submissions made by learned counsel for both these sides, this court is of the opinion that perusal of the records pertaining to the process involved in appointments to promotion of the respondent number 5 to the post of Anganwadi worker would be necessary. As such, the learned government advocate Assam to requisition the records and place the matter and place the same before this court on the next date fixed. List this case again after 4 weeks.
Public.
Public.
Right, please, Lord. My lord, in this case, my lord, the home guards like the petitioner was not allowed to, my lord, participate in the recruitment process for the, my lord, Assam Industrial Security Force, my lord. This honorable court, my lord, interfered lordship and directed the authorities to allow them to participate, my lord. 8 candidates were there, among them lordship petitioner, my lord, were successful lordship. My lord, but the kindly see page 47 lordship. My result was not declared.
Which was the fake certificate submitted by him?
Lordship, these are the computer certificates, Lordship.
Which one was fake?
Lordship.
Why was his candidature rejected?
Yes, Lordship. After verification, Lordship, after scrutinize and verification, the computer certificates submitted by the candidates are come to that conclusion that it is a fact certificate, Lordship.
Which one is fake? Which certificate was found to be fake?
My lord, kindly see paragraph 11
Please
of
take your
the
seat.
ADP law.
Please take your seat.
Yes,
Please take your seat. Mr. Goswami.
Perhaps, Lordship, in the last occasion, Lordship, as per the direction of this honorable, we write a letter to the authority that to produce the outcomes of the scrutiny committee who scrutinized and verified the computer certificate submitted by the petitioner, Lordship. And that instruction is not yet to be received, Lordship. If that in that instruction, Lordship, it may categorically define regarding the findings of the scrutiny and verification, Lordship, by the committee.
Take down heard Mr. M.H. Ahmed, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam appearing for the state. The petitioner had participated in the recruitment process initiated by the respondents on the basis of advertisement notice dated. What is the date of the advertisement notice?
My lord, initially it is 13/12/2013, and my lord, it was addendum was there 27/10/2021.
13/12/2013. And addendum dated 27/10/2021 based on online application system. The petitioner claims to have appeared. The petitioner claims that he had appeared in the written test conducted by the authorities, but when the results were declared, he was disqualified on the ground of submission of fake documents. First up, Mr. Ahmed submits that no particulars of the alleged fake document submitted by the petitioner has been furnished till today. First up, taking note of the stand of the petitioner, this court had passed order dated 11/4/2023. Issuing notice in the matter and also directing the learned government advocate Assam to produce the records, including the fake certificate allegedly, including particulars of the fake certificate allegedly relied upon by the petitioner. Today, when the matter is called up, the record has been made available, but there is no mention of the alleged fake certificate relied upon by the petitioner. Mr. Goswami, six weeks more time, further time to obtain complete instruction in the matter. Prayer allowed. Let this matter be listed again after 6 weeks. However, having regard to the facts and circumstances of the case, as an interim measure, it is provided that one post of home guard.
No, Lordship.
Then one post of
Constable Assam Industrial Security Force Battalion.
constable in the Assam Industrial Security Force be kept vacant, awaiting final order in this recommendation.
So like that.
Right, Mr. Lordships, kindly peruse the order dated 11/11/2022.
Lordship, in that order, Lordship,
11/11. And in paragraph, my lord, 3 and 5, my lord. As regards the first prayer of regularization, issue notice returnable by 6 weeks. And then, my lord, paragraph 5, as regards the second prayer, the petitioner to submit a representation before the circle officer so and so claiming his salary. And the circle officer to pass a reason order on the same.
What is the instruction?
According to my lord, we have filed a representation, my lord, and submitted by way of additional affidavit, my lord, on 10/2/2023, my lord.
You have filed additional affidavit?
Yes, my lord.
For when?
Filed on 10/2/2023, my lord.
10/2/2023.
Yes, my lord. My lord,
Yes.
page 39, my lord, the representation, my lord. We have already submitted before the
Yes.
circle.
What has happened?
yes, Lordship. Lordship, first of all, Lordship, the as per the order, dated that order, it is 2013, 13 orders, Lordship. This office is not fixed any DDO of the petitioner, hence it will not have been able to response of this query. Query means query regarding the area salary, Lordship. And other Lordship, in other queries, Lordship, whether the petitioner has been still working in the office, Lordship, that is in positive, Lordship, he is working still now, Lordship. This is my instructions.
So what is to be done now? He is working, but you will not give him his salary. Is that your
Lordship,
stand?
but Lordship, the selection, I think the DDO was not fixed at that time, Lordship. And so far the order or is order dated, Lordship.
No, Mr. Goswami, I find it very difficult to understand what actually are you saying. He has come before the court saying that please regularize my services since I've been working at a fixed pay of 1,000 per month since long. I've not also received the arrear salary. So the court says obtain instruction. And on the second prayer says file a representation and the authorities to act upon it. What really is your stand in the matter?
Regarding instruction, regarding the representation, Lordship, I have no further instruction on that regard, Lordship, regarding representation, Lordship. I have to confirm the instruction, Lordship. Regarding the representation, what is the file?
All right, you wait for some time, then we'll pass a mandamus. What is your stand?
Yes, Lordship, regarding regularization, Lordship, the petitioner was appointed as per his documents, Lordship. He was appointed in 2013. So he is not covered by the Upenda's judgment because 10 years of continuous service is required from 2017, my lords. From this document, we can say he was appointed in February of 2013.
10 years of service from 2017,
my lords, when the Upenda's judgment was passed, my lords, where he is claiming for regularization and minimum of the pay scale, my lords. That we are claiming as per our instructions, he is not entitled to. Regarding arrear salary, my lords, that has to be that is the concern of the administrative department. For regularization, Lordship, if Lordship directs, we'll file an affidavit whereby we are
file an affidavit.
Lordship will file the affidavit.
Mr. M.H. Ahmed, learned counsel for the petitioner, also heard Mr. J.K. Goswami, learned government advocate Assam, who submits that a copy of the additional affidavit filed by the petitioner on 14/2/2023 in terms of the order dated 11/11/2022 passed by this court has been received by him, but he be granted 4 weeks time to complete his instructions on the same and file rejoinder. Mr. H. Shalia, Learned Standing Council, Finance Department, has also prayed for 4 weeks time to file affidavit responding to the prayer for regularization made by the petitioner. In view of the above, this matter stands adjourned for 6 weeks. The Learned Departmental Council to positively file affidavit within 4 weeks from today by serving advance copy upon the petitioner's counsel. 30/31 with the same order.
May I please your lordship? Lordship, in this case, penalty has been imposed without giving charge sheet and also without giving an opportunity of cross-examining the witnesses, lordship. So lordship, on the last occasion, respondent was supposed to file affidavit. But till now, no affidavit has been filed.
Who is appearing for the respondent?
PWD, counsel for PWD, lordship.
Mr. Nani is appearing. All right. Where is the impugn order?
Lordship, on page 59, lordship. The operative portion is on 61.
So there is only a censure, that's all.
Censor and, yeah, taking his suspension.
So here he has given an undertaking that he will not repeat it. What is there in it? What is there in this case? There's nothing.
Lordship, but penalty.
Censure can be done even without an inquiry. That's there in the act.
Lordship, let them file an affidavit, lordship.
We will close the matter today. What affidavit is to be filed? You have a copy of this disciplinary. Take out the book. For a censure, no inquiry is required. You are saying the inquiry was not conducted properly.
Lordship.
But even inquiry is not required to be conducted. And what has been done here, only censure and his period, suspension period has been.
Suspension period has been treated as leave, lordship. At his
That's all. That's not a penalty.
Lordship.
What is your answer?
Lordship. Just let respondent to file affidavit, lordship. They were supposed to seek instruction and they were supposed to file affidavit.
Without the instruction, I'll dismiss the petition. If they get instruction, I'll dismiss it twice. You want dismissal twice or once? Have you read the file? Have you read the brief?
Lordship.
So I am saying censure does not require a departmental inquiry.
Lordship.
You are saying the departmental inquiry was not properly conducted.
Lordship.
What is the way forward then? Censure is just a warning. Don't do it. That's all. You are not prepared. On the request of Ms. Bibi Hussain, Learned Counsel for the petitioner, this matter stands adjourned for 4 weeks. None is appeared for the department, although the name of Learned SCPWD is shown in the cause list.
Much obliged.
Item 33.
Matter is relating to compassionate appointment in Canara Bank, lordship. On the last occasion, respondents were directed to file counter affidavit, lordship.
2 weeks time may kindly be granted.
Heard Mr. G. J. Sharma, Learned Counsel for the petitioner, Ms. S. Chakravarti, Learned Standing Counsel, Canara Bank, appearing for the respondents, prays for and is granted 2 weeks time to file affidavit. Let the matter be listed accordingly.
Highly appreciated.
Item 34.
matter relating to promotion from Anganwadi helper to Anganwadi worker. The petitioners before the lordship were Anganwadi helpers, your lordship.
Yes.
Earlier approached this honorable high court and passed in order. Operating part at page 62, your lordship.
What is your prayer?
Now, my lord, they have rejected the claim of the petitioner only on the ground that the petitioners claim for upgradation to the Anganwadi center, which falls under different ICDC projects, but within the same revenue village, my lord.
So has somebody else been appointed?
No, my lord.
Post is still vacant.
Vacant, my lord. Is still vacant. But so far guidelines are concerned, my lord, specific provision is that within the same revenue village, promotion can be allowed, your lordship. But
Yes.
ICDCS project.
Where is the order of rejection?
At page 66, your lordship. 66, 67.
So where is the petitioner serving?
Serving under Dharmasala ICDCS project. Varipur Dharmasala ICDCS project, my lord.
And what about Anganwadi worker in Dharmashala ICDS project? Who is occupying that post?
That post is vacant, my lord. Where he is claiming for upgradation, that is vacant, lying vacant.
Yes, why are you not considering her for that Dharmashala ICDS?
Lordship, in the order dated 13 December 2022, Lordship, it appears that that the petitioner.
All right. Heard Mr. A. Rahman, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam appearing for the state, assailing the order dated 13/12/2022, passed by the Director from a Women and Child Development Department, Assam, rejecting the prayer of the petitioner for upgradation / appointment as Anganwadi worker. The instant writ petition has been filed. In the impugned order, it has been observed that the petitioner does not serve as petitioner is not working as Anganwadi helper in the jurisdictional area of Gauripur ICDS project. Rather, she is serving as Anganwadi helper of another ICDS project. Full stop. According to Mr. Rahman, the concerned ICDS is Dharmashala ICDS project.
4 petitioners.
The petitioners are, according to Mr. Rahman, there are vacancies of in the post of Anganwadi worker under those ICDS projects wherein the petitioners are serving. How many petitioners is here?
4 petitioners, same category, my lord. 4 revenue village, in each revenue village 2 Anganwadi center, one for another one.
If that be so, the impugned order does not reflect as to why their cases could not be considered for appointment as Anganwadi worker under those ICDS projects under which they are working. First of the learned government advocate to obtain specific instruction on the aforesaid aspect of the matter and place it before this court. Let this petition be listed again after 4 weeks. Yes.
My lord, they have also made advertisement, my lord. There is some urgency, my lord.
4 weeks.
Some stay may be given, my lord. In
Next
respect
matter,
of
please.
the advertisement. I have annexed the advertisement also.
In this case, the respondent is supposed to file their affidavit. Lordship, 3 weeks time may be granted, file the affidavit.
Mr. H. Shatri, Land Council is present on the petitioner on the
Lordship,
request of
N.K.
Mr.
Sharma on behalf of Mr. H.K. Das, SCGHE for respondent number 3, 4 and 5, Lordship.
On the prayer of Learned Council for the respondent numbers 3 to 5, seeking time to file counter affidavit. This matter stands adjourned for 4 weeks. Ms. S. Borua, Learned Government Advocate Assam is present on behalf of respondent numbers 1 and 2.
Deeply obliged, Lordship.
Yeah, please, your lordship. My lord, the case of the petitioner is rejected, my lord, page number 40, my lord, the relevant part.
Why it was rejected?
My lord, that he was minor at the time of the death of his father, my lord. Petitioner had earlier approached this one in the courts, my lord.
What is your instruction?
Instruction not received, Lordship, and he was minor, so rejected.
When was the application filed?
My lord, execution was filed, my lord, 687, my lord.
6/8/2007.
7, my lord.
Nothing can be done, but we'll dispose all these matters in June by clarifying the law.
Oh, my-
2007, you were
My lord.
minor, now you want to get appointment.
My lord, from 2012 on several occasions, they have approved this honorable court, my lord. The
Cannot-
order I have
cannot.
annexed, my lord.
Heard Mr. M.J. Kari, Learned Council for the petitioner. Also heard Ms. S. Borua, Learned Government Advocate Assam, who submits that instructions are still awaited and therefore this matter be adjourned for 4 weeks. Prayer alone, list accordingly.
Obliged.
May it please your lordship. Petitioner before lordship, my lord, is a retired person. He was retired on 31/11/2021, my lord, as a chief accounts officer, Hailakandi Zilla Porishad, my lord. And my lord, he was after retirement, my lord, one show cause was issued, my lord, which was violating the provisions of my lord, article 12, my lord, rule 21, my lord. And my lord, I came for the honorable court, my lord, challenging that, my lord. And my lord, please may kindly see page 47. This is a show cause notice, my lord, issued on 35/2022, my lord. My lord, and my lord, issue was issued, my lord, institute on 16/10/2014, my lord. My lord, and after, my lord, more than 7 years, my lord, they now, my lord, after retirement, my lord, they filed show cause notice, issued a show cause notice, my lord. It cannot, my lord, go, my lord, as per rule, my lord, 21, my lord.
When did you retire from service?
I am retired on service on, my lord, 31/11/2021, my lord. And
31/11, November doesn't have 31 days.
my lord, sorry, I am sorry, 35, my lord, yes, my lord. 30/11/2021, my lord, I'm sorry for that.
So are you not getting provisional pension?
I am getting provisional pension, my lord, but this so cause was bad in law because of that rule 21B, my lord.
Where-
So
where
thereby,
is Rule
honor-
21?
yes, my lord. This book. Rule 21, my lord, B, my lord. Page 11, my lord. 10 and 11, my lord. B, my lord. 21B, such departmental proceeding is not instituted while the officer was in service, whether before his retirement or during his re-employment, shall not be instituted save with the sanction of the governor of Assam. 2, my lord, shall not be in respect of any event which took place more than 4 years before such institution, my lord.
My lord, this, my lord, event was issued on 16/10/2014, my lord. Now, my lord, it's more than, my lord, 7 years, my lord. And see, my lord, no such judicial proceeding if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be instituted in respect of cause of action which arose, even which took place more than 4 years before such institution, my lord. My lord, this proceeding, my lord, cannot be instituted after retirement, my lord, my lord. My lord, please kindly see, my lord, charge number 1, my lord. If one of would permit me, my lord.
Where is it?
Page 47, my lord. Middle paragraph, my lord. After disbursement or amount, the beneficiaries will hefty amount of the scheme remain in unspent and disbursed. You are entered into a conspiracy with the official district level, state level purchasing committee and other official director of social welfare and coalition with MS so-and-so, money so-and-so to execute the plain. Director of social welfare has falsely shown quotation notice published details that is 16/10/2014, my lord. And my lord, I was, my lord, FIR was lodged on 10/6/2016. If I'm going to say from the FIR also, the more than, my lord, 4 years, my lord. I brought in some judgment, my lord, to our high court, my lord. এখন দি দিয়েছে। I brought in citation, my lord, before 2007-1 GLT 533, my lord. The Service Law Assam Services Pension Rule 1960 Rule 2001 Payment of Assam Service Pension Rule 21B2 Petitioner retiring from service on so and so cause notice dated 2004 alleging non-payment of balance so and so, my lord. Paragraph, my lord.
Yes, Mr. Chalia, so we'll satisfy the order.
Lordship, here,
You have not filed affidavit despite.
no,
the-
Lordship, we were given an opportunity. We received the instruction, Lordship, we could not conclude the disciplinary proceeding because we were awaiting certain documents from the Social Welfare Department, which we have not received till yet. And we have issued this show cause under Rule 21, my lords, which allows withholding of pension from a retired officer when there is grave misconduct on the part of the petitioner, my lords. Under Rule 21, we have issued this notice, my lords.
Rule 21, which.
Rule Assam Service Pension Rule, my lords. Withholding of pension from the retired government servant for grave misconduct done during the period of service.
Mal guilty, found guilty. If in departmental or judicial proceeding, pensioner is found
If
guilty.
he is found guilty, then only you can.
The Supreme Court
Lordship,
cleared.
we are trying to, like, as per instruction, Lordship, we were just trying to conclude the departmental proceeding, but because of certain documents which we had asked for from the Social Welfare Department.
These are your rules. How
Yes,
can you
Lordship.
act contrary to your rules?
Lordship may grant me a short date, because in the meantime, Lordship will get the approval if required.
You see the last order, it was not clear.
Lordship, I've seen the last order. Lordship, let the matter be passed over for a timing, Lordship. I'll get the appropriate instruction.
At the most at 2.
Lordship.
I'll pass orders today.
Lordship.
Because once this court passes an order, it will be followed.
Lordship.
It was made clear that if you don't
Yes.
file affidavit, it will be.
Yes, Lordship.
followed.
Lordship, at 2.
So don't make a request to adjourn.
Lordship, no. Definitely.
You had your chances, you did not take.
Yes,
it, so
Lordship.
what can be done?
At 2, Lordship. March.
Keep it for 2.
Lordship, in this case, we have received instruction. We'll file our reply, Lordship.
All right.
For which
Now
time?
the petitioner, Mr. B. Chakraborty, learned So this is submits that he has received instructions and would file affidavit
Counter affidavit.
within
3 weeks time.
3 weeks from today. In view of this, are you appearing in this case?
No, no, I'm not.
Then you
Next
are-
item. my lord.
Oh. In view of the above, this matter stands adjourned for 4 weeks. Interim order must allow to continue.
Lordship, this is with regard to the arbitration application.
Where is the railway?
Gogoi should have appeared, your Lordship.
Take it up at 2.
Yes, sir.
May it please, your lordship. Herein, my lord, the respondent number 2 was the employee of the petitioner management, my lord, and he was dismissed from service. After his termination, industrial dispute was raised. And on failure of conciliation, it was referred to the Land Labour Court, Guwahati. And the Land Labour Court, my lord, passed award. It is on 18/9/2017. By that award, it is awarded that he is to be reinstated with full back wage. We preferred repetition that was dismissed and award was upheld. Accordingly, we ordered for reinstatement. He did not join. He did not join, my lord. And subsequently, he made.
Who are you? Who are you?
I am the management, my lord.
Management of?
Management of Purbanchal Educational Welfare Society. So then he made a communication that there was 2 parts in the award, reinstatement and back wage. We passed the order for reinstatement and there was no mention about back wage. And earlier we afforded him 7 days time to join. He did not join. After his communication, we replied that we are paying the back wages shortly and we given him another time to join, but he did not join. Subsequently, he made an application before the London Labour Court under section 33C2 for back wage. And in fact, there was no dispute regarding payment of back wage. During cross-examination of management witness, it was revealed that
You are filed this writ petition against which order?
against my lord, order dated 1/9/2022.
Where is it?
It is
number?
at page 100, my lord. Page 100. The representative of the workman who made an objection regarding his authority to represent the workman as per section 36 of the Industrial Disputes Act. That was rejected. Lordship, may kindly look at page 101, the operative portion. Last paragraph.
Yes.
Undisputedly, the instant exhibition case is an execution case. Case was registered under section 33C2 ID Act to enforce the award dated 18/9/2017, passed in reference case number 3 of 2017, in which the present management and the applicant were parties. It is clear that during the adjudication of reference case number 3 of 17, the management did not raise any objection, even if Mr. B. Kolita represented the workman or the present applicant. Therefore, in my considered view, objection raised by the management side in the instant execution proceeding is not tenable. And accordingly, our objection was rejected, my lord. But as per section 36 of the Industrial Dispute Act,
So this is only about representation of the workmen by someone.
yes, my lord.
You are agreed by that order.
My lord.
Why?
But as per section 36 of the Industrial Disputes Act, person who is to represent the workman is to be the executive member of the trade union to which the workman belongs, or the executive member of the federation to which the trade union where workman is member belongs, affiliated to that federation, or the co-worker. But this, Sri Bachandra Kolita, he is not within this prescription. Lordship, may kindly have a look at page 103, the authority letter. The authority, I the undersigned.
You are for the workmen.
Yes.
Why can't you get someone who falls in the prescription? Otherwise, we'll
My lord,
admit and we'll hear the matter. Today we'll not be able to finish it. It will come in the usual course. It will unnecessarily cause delay to you.
yes, my lord.
Can you not find someone?
My lord, but he is a official of a recognized trade union, which is registered in Delhi.
So that aspect will be decided by the labor court. Then we.
Yes, my lord.
But
The writ petition
only
has
thing
not,
is that
it is a matter
he
of
falls
fact, my
under
lord.
the prescription of this section 36. We do not have any objection, my lord.
That aspect will be considered by the.
But the labor court did not consider that aspect. It is why.
My lord, that is because this initial, this issue should have raised in the first reference case itself. They did not raise this issue.
No reference case.
Thereafter, they raised this issue in the middle of the execution case, in the middle of the cross-examination. My lord, if I may place one submission, the person was terminated in the year 2016. His basic monthly salary was only 8,200 rupees. My lord. He has been fighting a case since 2016 till today.
In that
And
regard,
this is an
Lord,
unnecessary litigation for which they have come
not
before
my
this.
official submission. But
Second,
now what-
my lord, another point under section 36, there's a bar for legal practitioners to present a case before the labor without seeking any without having the taking permission from the workmen. They have not taken the permission from the workmen, but we did not raise objection on that. So at this stage, bringing up this issue, even though he is an official member of the registered trade union, I think it is nothing but a waste of time, my lord.
Lord, what happened in this case? Although my letter has submitted, only because of this gentleman, the problem has arose. Because I personally made submission before the labor court that we are ready to pay the amount.
Do it right now.
Lord,
You deposit the amount next week.
But right
Then
now,
we'll hear your case.
it's not.
Whatever the amount.
Because I have to get instruction from
You get
now,
instruction.
Lord.
You
I
get
personally, but the workman says that management's officer is
How
to
much
come and-
amount you have to pay him? What is the amount?
4,95,500.
That is not the amount, Lord. It is till date of
According to you,
reinstatement.
what is the amount?
We have to calculate till date of reinstatement. We are ready to pay.
We'll have it on Wednesday and you will deposit
Well,
the amount here. After
Wednesday-
that, we'll hear you.
Wednesday, Lord, can it be next week? Lord? I will be.
Next Wednesday is next week. This week, there is no Wednesday. After Friday, there is no Wednesday in this week.
17th.
Huh?
17th.
17th is Wednesday.
I'll try. I'll try. 17th. I had some problem. I'll try my best. I had some personal problem. That's if
You have
there
problem.
I have some problem. Lord. If
Then when do you want it? 18?
can it be on 19th or 22nd? if
19th,
possible?
my lord.
Then 15th.
Yes,
You have a
17th,
long problem or a short problem?
17th. I'll try to accommodate. I'll take instruction.
You ask them according to whatever the amount you deposit it here. Let the workmen get the amount. After that,
I
you
made
see.
that statement. We're ready to pay it.
Pay it. Deposit the amount on Friday.
Well, 17th. I'll take instruction.
You take instruction
I'll
and
take
you
instruction
deposit it
17th.
by 19th.
7.
Yes, you pay the amount. We are legalities we'll see later on. People
No,
need to survive.
that
All right,
I
on the-
cannot
on the
make that
prayer of
submission
learned
that
case,
he's not entitled.
Learned counsel for the petitioner, this matter is directed to be posted again on 17/5/2023 as a fixed item so as to enable him to obtain instruction. What is the admitted dues of the respondent number 2? And how soon the amount can be deposited before this court? Miss
Ms. Das.
as thus learned counsel is present on behalf of respondent number 2. This S. Borwa, learned government advocate Assam has appeared for respondent number 1.
Till date of
First money,
reinstatement, he's
thereafter
entitled.
talk. Huh?
Till date of reinstatement, he's entitled. That
Give
I
that
cannot-
money, put it here.
He's entitled.
By 19th, you have to pay that money. Then we'll examine your legal issues. You followed?
Then everything will over. Much obliged.
All right.
Item 43 for others.
Well, in this
Admission is
matter,
over.
my lord, you will also find that as per the Lavazima court report, my lord, service on respondent number 7, 8, and 9 complete, my lord.
Other respondents are already.
Earlier completed, my lord, but they have not filed any affidavit, my lord.
Okay, and you are
Though-
appearing for whom?
I am appearing,
No. Take down hard mistake, commercial and counsel for the petitioner. Peruse the Lajima court report order dated 3/5/2023, according to which service of notice on respondent numbers 7, 8, and 9 are complete in this case. Yes, sir. Mr. S.M. Hassan, learned counsel is present on behalf of the
Lordship, I'm appearing for respondent number 1, 2, and 3, Lordship.
1, 2, and 3. Mr. Maheshwari submits that service of notice upon all the respondents is complete in this case. In view of the above, register to verify and list the matter for admission hearing after 10 days.
They have not filed affidavit, my lord.
In the after 2 weeks, in the meantime, the respondents may file affidavit if so advised.
Yes.
Wait, please, my lord. My lord, in this matter, we have sent a notice to a client, informing them that we are withdrawing the
Mr. A.K.
wakalatnama.
Borwal, learned counsel for the Borwal, learned counsel for the petitioner submits that his client has already been noticed for withdrawal from the brief, and therefore this writ petition be listed again after 4 weeks. Prayer allowed. Register to verify as to whether any new counsel has entered appearance for the petitioner and let the matter and notify the matter accordingly.
I'm obliged, my lord.
Yes.
Your Lordship, I am for the applicant, Jalanagar Development Private Limited. Your Lordship, notices were issued on the application under section 466. On the 26th of July, no reply has been filed to date. And the one-time settlement offer is still under consideration. No resolution has been reached.
Your lordship, there is no pending one-time settlement because bank has informed me that there is no pendency and all has been rejected. So kindly allow me 2 weeks time to file and reply. The matter may be taken up for hearing.
Who is the applicant here?
Jalanagar Development Private.
No, you are for the applicant.
Yes, Your Lordship.
What is the application about?
Your Lordship, the application is about stay of winding up proceedings. Winding up proceedings were initiated against Chota.
You are Miss M. Das.
Yes, Your
Miss
Lordship.
M. Das, learned counsel has appeared for the applicant hearing. Mr. M. Sharma, learned counsel appearing for the bank, submits that all proposals made by the applicant for OTS have been rejected by the bank, and therefore he be granted 2 weeks time to place the said facts on record in the form of an affidavit. In view of the request made by Mr. Sharma, this matter is directed to be listed again after 3 weeks. In the meantime, affidavit on behalf of the bank be placed on record.
And your lordship, in this case, official liquidator has not yet been filed his report.
Who is appearing for the official liquidator?
Your Lordship, notices were served upon the council as directed by the court.
Registry to notify the matter again by reflecting the name of learned counsel representing the OL in this case. All right, I'll rise now. There's some meeting. We'll again continue at 2.
Obliged, Your Lordship.
My lord, in item number 34, my lord, the government has already filed affidavit, my lord. Your lordship has granted 4 weeks time for instruction, my lord. So next week may be taken up, my lord.
No.
Government has already filed affidavit, my lord.
My lord, regarding item number 46, my lord. He appeared.
47 was called, Lordship, 46 was not called. In this case, Lordship, I enter appearance for respondent 1, Lordship. So for respondent 2 and 3 is concerned, Lordship, they are not in the respective post, Lordship. So probably they have to be newly incumbent, have to be implemented, Lordship.
Ms. B. Devi, learned counsel for the petitioner is present, item 46. Mr. N. Upadhyay, learned counsel has appeared for respondent number 1 and 6, time to file affidavit. However, according to Mr. Upadhyay, the respondent numbers 2 and 3 are no longer in service. In view of the above, this matter be listed again after 4 weeks.
They are not in the respective post, Lordship. They are in service.
They are not in the, they have been transferred in the meantime. And therefore, the new incumbents are required to be implemented.
They are not retired, my.
So after 4 weeks, was to enable the petitioner to implement the present incumbent in the office responsible for implementation of the court's order, Mr. Upadhyay, to in the meantime file affidavit.
Obliged.
My lord, here, what happened, my lord? The FAO is there, where, my lord, the interim injunction was not granted. The humble submission is this, my lord. The entire matter may be sent to trial court for hearing on the matter within 2 or 3 months, my lord. Injunction matter can be disposed of by the trial court. This court.
Why this is a FAO?
FAO, my lord.
Why this is before this court?
No, before this court, because the valuation, my lord. before this court?
No,
because of-
no, this is
before
bench
this-
free,
Huh?
civil bench free.
Oh, I do not know, my lord, why this has come.
My
That I
lord,
can't- But anyway, my lord, my full service on my lord, the entire matter can be, all cases can be disposed of. Our violation petition is there, we may be granted liberty to file the petition there because some evidences may be laid, my lord, there. The entire, this appeal may be disposed of, my lord, your lordship's order is there initially. Getting petition because. My lord, your lordship's passed the interim order, my lord. That was there. Nice order to go. On 24/5/19, my lord, your lordship passed an order. And the entire matter, my lord, is to be disposed of by the trial court because the matter has not been heard there.
You are seeking an order today itself.
Well, it can be disposed of, my lord. I have even a suggestion to my learned friend also, my lord. Why this matter should be pending here, my lord? Because trial court has not applied its mind, my lord. They have because the entire injunction matter has not.
No, but first of all, I would like to know why this civil bench one matter has been listed before.
That I do not know, my lord. I'm sorry, my
So
lord.
these are things which create
No, no, my lord.
unnecessary controversy.
There is a reason behind perhaps, my lord, the order which is sought to be, my lord, modified, for which the IA has come up. That order was passed by your lordship at page 101.
Page 10?
101. The order that is now
That
sought to be.
24/5/19 order, my lord, the
Yes.
first order in the injunction petition.
And the IA that has now today been listed before.
So
before your
even then, there is no requirement to
That,
list.
that requirement is not there. Even in another case also, my lord had put the query and I was, my lord, there to submit that that is not necessary. It's not a review petition. It is only for modification.
Is it necessary to list it before the same court?
Well, it is not necessary. my lord.
What happens is otherwise these are jurisdictions created under the authority of the Chief Justice.
So if your lordship should, my lord, take up, my lord, my humble submission, this entire matter can.
Then let it be listed next week with an office note. If there is an office note posting it before this court, then it's fine.
And my prayer would be. And my prayer would be, my lord, if your lordship is taking up next week and my senior colleague is insisting on the appeal being heard, can it be on a can it be on a hearing day?
Heard Mr. J. N. Sahiwala, learned senior counsel appearing for the appellant. Also heard Mr. D. Chakravarti, learned counsel representing the respondent.
1 and 2.
Respondent numbers 1 and 2. It appears that this is a matter pertaining to civil bench 1, but the case has been listed before this court, which is taking up civil bench 3 matters. First up, it is pointed out that by filing IA bracket civil number 2786 of 2022, arising out of FAO number 29 of 2019, a prayer has been made to modify vacate the order dated 24/5/2019 passed by this court in the connected appeal. First up, however, it is not known as to whether there is any requirement for listing the matter before the same court which had passed the order sought to be vacated. Registry to therefore verify and list this case before the appropriate bench in the next week. Let me put a date on 18th. 18th of 18th of May 2023, along with appropriate office number.
Obliged.
May it please the lordship. Lordship, the contender number 1, who was at the relevant time the Commissioner Home Department, he has since been transferred to the Commissionerate of Police. So probably we would have to take fresh steps and also to implement the present incumbent. Our respondent number 2, contender 2 and 3, they have been represented.
Lordship. I'm appearing for 2, your lordship.
I'm appearing for 3, lordship. We'll file our affidavit.
No, but what is the order of the court?
Lordship, the order was to decide the claim of the petitioners regarding the parity in pay between the class 2 officers of the Home Guards and the APS grade junior police personnel in view of the recommendation of the pay commission. That was communicated way back in February 2022. But till now, the claim of the petitioners have not been decided.
Within 3 months.
Yes.
What is the date of the order?
That is 10th of February 22.
So it's more than a year.
Lordship, in this, finance has already rejected the claim, my lordship. That is what I'm trying to bring on record, my lordship.
Where is it?
Lordship, this matter has come for the first time today, lordship. Otherwise, I seek some time to file the affidavit, my lordship. We'll bring it on. record.
Rejected the claim, then it is a fresh read petition. Why you want to
No,
impede
it has
that?
not been communicated.
Lordship, we have, lordship, this opinion of the finance department was asked by the home
All right,
department. my
heard Mr.
As doctor.
As Dr. Learned Counsel for the petitioner, also heard Mr. A. Fukun, Learned Counsel for respond number 2, and Mr. A. Chalia,
Respondent number three,
counsel appearing for the respond number 3, who submits that in terms of the order dated 10/2/2022 passed by this court in WPC number
5147 of 2014.
5147/2014. The
And-
matter has been examined by the competent authority, and whereafter the finance department has rejected the claim
Lordship,
of
the opinion was fought from the finance department. They had rejected the claim of the
petitioner. Mr. Chalia, 6, 10 days time to place the said facts on record in the form of an affidavit. Prayer allowed, registered to list this matter again on 24th of May 2023 as a fixed item. Affidavit on behalf of the respond number 3 shall be positively brought on record on or before 22nd May 2023 by serving advance copy upon the petitioner's counsel.
24th, I have some difficulty.
Then we'll have it on 26th. 26th, and will be positively brought on record on or before 24th. Let us see if the matter has been decided. You
Then it will
close
be a
it.
fresh cause of
Yes, Lord.
Yes.
I was selected as the village headman of charge number 6 of under Kolgesiar police station in the district of Borpeta, my lord. Now the opposite party number 1, who was the writ petitioner, filed a writ petition, which is a premature one because I was only selected, not appointed. So as per rules 185, if appointment is met or suspension is met or dismissal is met, then only appeal lies. Now, no,
Tell him,
now, what happened, my lord?
show him, show him.
No, I have also, my lord.
Where is the division bench order?
Now, even if for the sake of argument, it is maintainable. Now the question is this, my lord, they have made certain allegations against me. And your lordship asked that if the allegations are not yet inquired into, then he may not be appointed. But everything was inquired into. And thereafter I was selected. But he misled the Honorable High Court and got some order for which my appointment has been halted. All others have been appointed. Now they say that we have also filed an appeal, departmental appeal before the Commissioner Lower Assam. But we have seen there is no such appeal. And we have kindly see page 49, my lord.
49 of?
49 of the writ petition, my lord. They have filed, they said that.
Give me the writ petition.
49, that is the one allegation that my wife has made some allegation. And that wife, my lord, she has gone from me since last, my lord. Sorry, my lord. It will be page 55 of the writ petition. 55.
So the appeal was required to
Now-
be disposed of within 60 days.
thing is this, my lord, no appeal is filed. That is the question.
Sorry?
They have annexed the appeal, and that is kindly see 55, annexer 11. There is no number.
We had filed the appeal, but it was not numbered. That is why we came up again before this
That is
honorable
problem.
court.
How, when it is filed, from the affidavit, it appears they have filed in March, 15 March. Kindly see page 14 of the writ petition. 15 March it is filed, and today we are on, that is, today is 14th of May.
14th, 12th.
12th, sorry, 12th of May. Now, 15 March they have filed, March, April, May, nearly 3 months. So it is not yet listed. So is it believable that within 3 months?
What has happened to his appeal? There is an order of the court.
The court's order may be seen page 47, my lord, of the IA. For which my appointment has been page 47, can you see?
Writ petition has been disposed of.
Yeah, disposed of. But for your lordship's order, lordship has asked the commissioner to party to file appeal, department appeal. There is no problem. But thing is this, due to your lordship's order, my appointment is halted. Kindly see page 47.
Maybe it was supposed to be altered. You filed a IA in a disposed of petition to vacate an order passed in that petition. How
But
is it?
we have no
maintained?
alternative because they say.
File an appeal then. What did the court say? Then make a verification and then issue.
Yes, that is my prayer is also that it is already verified. They misled the honorable court.
No, how can IA be filed in a disposed of writ petition to modify an order passed therein? Mr. Mahmood, there is a limit to things happening.
No, my lord.
You know how it is.
Because
why do you do things where every time the court has to make strong comments? Why do you do it? It is not permissible. There are hundreds of judgments. Supreme Court decisions are there. You cannot file any application in a disposed of case because the court is functions officio in that matter, except when it is a matter of clarification of a typographical error. Again and again, you are
that is
filing.
also my prayer, man. That is also my prayer. My prayer is not to set aside.
He can file an application before the lower Assam division.
Lower Assam division, there is no appeal because I have no cause of action. They said they have filed.
All
but
right.
that
Mr.
is
Mahmood, nothing
not
can be
yet
done. The
numbered.
writ petition has been disposed of, so
Yeah, that is true.
cannot be done.
But that was disposed of in my absence, my lord. That is why I could not say.
Then you have to either file a review or file an appeal. How can you file an IA in a disposed of matter? This is not even a review petition.
It's true. It is a modification petition only, simply modification.
Right, heart, Mr. M.
Then but one thing, my lord, liberty to file a review that may be granted.
This IA has been filed with a prayer to modify / vacate the order dated 27/3/2023 passed by this court in WPC number 1533/2023. It appears that by the order dated 27/3/2023, the writ petition itself was disposed of by this court. Therefore, the IA has apparently been filed for modification of an order passed in a writ petition which was disposed of. Full stop. Such an application, in the opinion of this court, is not maintainable in the IF law. Similar as the stand of Mr. T.C. Chutia, learned additional senior government advocate Assam, Mr. J. Hendrik, learned standing counsel, Revenue Department Assam, and Mr.
M.R. Chaudhary,
M.R. Chaudhary, learned counsel appearing for the
opposite party
opposite
number 1.
parties to writ petitioner. Be that as it may, in view of the prayer made by Mr. Mahmood, this IA stands disposed of on withdrawal with liberty to pursue appropriate legal remedy as may be available to the applicant.
Obliged, Lordship.
What is this matter? What order?
No, my lord, we are challenging the age criteria which had been fixed, my lord. My lordships on that day also heard some issues, my lord.
No, this has been listed for orders today. For what order?
Lord,
This is fixed for today, Lordship. That Lordship was disposed of this matter. Last occasion, Lordship, he was second time.
My lord.
He fixed it. He was that.
Petitioner is under his, my lord. He cannot apply for the poll. So he challenged the horizontal.
Is it a good day to argue a matter like
No,
this?
my lord, I am. No, my lord.
What do you want then?
And because of the order, my lord, my appointment has been installed.
No, there is no stay order has been passed.
So there is a observation in the order.
What is the observation?
The first order, my lord.
Subject to appointment order.
He was allowed to function as in charge, my lord.
No. Till the regular appointment, because my lord, I am already holding the charge of the said office on the strength of a in charge basis, my lord. And in the meantime, the recruitment process has initiated by fixing the age limit maximum as 30. Now, my lord, as I am 24.
Maximum or minimum?
No, for the entry, my lord, minimum.
Minimum 30.
30, my lord.
How old are you?
At present, my lord, I am 24, my lord.
So you can't be
I
appointed.
cannot be. So, my lord, what has happened, they are issuing notification after notification. Initially, it was 21 years of age, my lord. Now they have enhanced sometime 35, sometime 30. There is no rationality, my lord.
That's all right,
My-
but as of now, as per the standing notification,
My-
you are not eligible.
No, I am not.
So then we'll hear the matter
My
in
lord,
due
my-
course. We'll
my-
vacate the stay order. That's all.
My lord, there is no such stay, my lord. Only
We'll
thing.
clarify that
Lordship. Please,
22 to 2023.
lordship.
My lord, my father was the Gaubura of that.
No, but what to do? You are not eligible.
My
You're
lord,
not
that
eligible.
limitation I cannot, my lord. But which is not supported by
You
law.
are always having tough cases, Mr. What to
My
do?
lord, I don't know.
Try to get a brief which is a little easier
My lord.
so that the court can give some relief
My lord.
to your
No,
client.
I have got many reliefs from my lords.
All right,
My lord.
but we have to do justice as per
My
law.
lord.
Nothing can be done. Heard Mr. A.R. Bhuial, any counsel for the petitioner. Also heard Mr. J. Henry Gladys, standing counsel, Revenue Department, Assam, appearing for the respondent number 1. Mr. T.C. Chutia, learned additional senior government advocate, Assam, appearing for respondent numbers 2 and 3. And Mr. R. Ali, learned counsel, appearing for the respondent number 4. Full stop. The controversy involved in this petition is pertaining to selection of respondent number 4 for appointment in the post
In
of Gav
charge-
Pradhan, in respect of which the petitioner is presently holding the charge on temporary basis. Full stop. By order dated 22/2/2023, passed by this court in the present proceeding, while issuing notice of motion, this court had directed that till the next returnable date, the petitioner be allowed to continue to hold the charge of Gaubura, of which
My lord, charge number 18 of Bagbor Circle, my lord.
of charge number
18 Mandia, Bagbor Revenue Circle. Page 75.
of
Annexure.
village Kanchanpur and Kharki under Mondua Moja in the district of Barpeta. Today, when the matter is called up, Mr. Ali submits that as per the existing notification, the petitioner is underaged and therefore cannot be appointed as a Gaubura. First of, under the circumstances, there is no justifiable ground to stall the appointment of the respondent number 4, who has been selected for appointment as Gav Pradhan. Gaubura or Gav Pradhan?
Now
Gav
Gav
Pradhan,
Pradhan.
not Gaubura, Gav Pradhan. The learned departmental council also submit that the minimum age for appointment of Gav Pradhan is 30 years, but the petitioner is aged 24 years as on date. Full stop. From a careful scrutiny of the averments made in the writ petition, I find that the said aspect has not been denied categorically by the petitioner. However, Mr. Bhuiya submits that there has been frequent and irrational change in the entry age of Gav Pradhans by issuing successive notifications, and therefore the issue needs to be thrashed once and for all. First up, Mr. Bhuiya has, however, submitted in his usual fairness that as per the existing notification, his client does not meet the age requirement. First up, in view of the above, this court is of the opinion that this writ petition would call for in-depth hearing. As such, admit the petition. Since the parties are already represented, no formal notice, no further notice is required to be sent in this case. Let this writ petition be listed for final hearing in the third week of July 2023. The parties may exchange pleadings, full stop. Pleadings in the meantime, full stop. However, having regard to the facts and circumstances of the case, and for ends of justice, the interim order dated 22/2023 passed in this proceeding stands vacated.
Obliged, my lord.
Regarding that issue, my lord, I also brought in Supreme Court judgment, my lord.
Where is that book that
Okay,
Some service pensioner.
so আপনি যাও কোথায় যাবেন নেক্সট সেশন আর দুটো অর্ডার আছে এজন দিন petitioner retired as
as my lord,
Chief Accounts Officer.
Officer, Hailakandi Jilla Porishad, my lord.
All right.
Impun Sokos notice was issued on 30/5/2022, my lord. And page 47, my lord. And before that, my lord, regarding that issue, my lord, FIR was lost on 10/11/2016, my lord. And my lord, petitioner was suspended 1/4/2017, and suspension order was set aside by the Honorable Court on 11/6/2020, my lord. Thereafter, he was reinstated and he was retired on 30/11/2021. But after retirement, my lord, so cause notice was issued. My lord, that so cause notice was challenged before lordships by your lordship, by Rule 21, my lord, by violating, my lord, Rule 21 B2, my lord, as and C, my lord. And regarding that issue, my lord, Honorable Supreme Court also, my lord, held that, my lord. So many, Honorable High Court, so many judgments are there, my lord, regarding it. So other two judgments also I brought. But regarding that issue, my lord,
so you only want pension, but the departmental proceeding will continue.
no, my lord, departmental procedure cannot be initiated after, my lord, 4 years, my lord. Institution of
Lordship, in this context,
my lord.
there's only one humble submission which I'd like to make, my lords. There was a delay. We could not issue the so-called memorandum because we did not have the adequate documents which was required from the social welfare department, my lords. It is only after we got the charge sheet of the director of vigilance, my lords, that we were able to initiate and send the notice of memorandum and the charge sheet, my lords. Lordship, here the department is only asking that because there has been a delay, my lords, that we are conceding to it. My lords, if lordship permits, if lordship gives us a direction within 3 months' time, now that we have the adequate, we can finish up the disciplinary proceedings, my lords. There was a delay, my lords. That
But
is.
he is saying, as per the rules, you can't do it.
Yes, lordship, that is the lordship. But here I'm just
My lord, before retirement is well possible, but after retirement, my lord, cannot, my lord.
Change your rules then.
No, yes, lordship, this is my submission may be recorded, my lords. If an opportunity is given, we can conclude the disciplinary proceeding within the lordship may reject it, my lords.
See, you know, even money taken from the bank cannot be recovered if it is barred by limitation.
Lordship,
That is a very stringent law.
lordship may just record my statement, my lords. That is all. We can proceed with the disciplinary proceeding and finish it off within 3 months if lordship allows, my lords.
No, the law says you can't initiate.
Yes, lordship,
it.
lordship may record my statement.
3 days. You can't initiate it for even a day. You can't, it is not just.
Within 4 years, my lord, lordship.
It is not maintainable.
Yes, lordship. My lord. This is the instruction which I had received from the department, which I just want to be recorded, my lords. That is it.
And which are these judgments?
Judgment, my lord, please may kindly see, my
Hmm.
lord, 2000, my lord, 1312 SCC, page 210, my lord, para 12 and 13, my lord. Para 12 may kindly see, my lord.
Para 12.
Para 12, my lord, may I read, my lord. Para 12, my lord. There is also a provision of Rule 43B which provides that such departmental proceeding, if not instituted while the government servant was on duty, either before retirement or during re-employment, shall not be instituted save with the sanction of the state government, shall be in respect of event which took place not more than 4 years before the institution of such proceedings, and say next, my lord, it is apparent that, my lord, below that, my lord, it is apparent that proviso speaks about the institution of proceedings. For initiating proceeding, Rule 43 puts some condition. Departmental proceeding is indicated in Rule 43B. If not instituted while the government servant was on duty, then it shall not be instituted except with the sanction of the government. It shall be in respect of an event which took place not more than 4 years before institution of the proceeding. Such proceedings shall be conducted by the inquiry officer in accordance with proceedings by which dismissal of service can be made. Thus, insofar as the proviso is concerned that deal with condition for initiation of proceedings and the period of limitation within which such proceeding can be initiated, my lord. It cannot be initiated, my lord, after, my lord.
This is same Assam pension rule.
Yes, my lord, same, my lord. Same rule, my lord. Assam pension rule 43, my lord. My lord, B, my lord, 2, my lord. One is shall not be instituted save with sanction of the governor of Assam. 2, shall not be in respect of any event which took place more than 4 years before such institution. Regarding that, issued 2 judgments before the by honorable Guwahati High Court.
Not Assam, this is Jharkhand.
This is Jharkhand, my lord.
Then why are you saying yes?
No. Similar, my lord, rule same, my lord. Same one, my lord, central rule is coming, my lord, everybody. And our High Court, my lord, page, my lord, I have already given, my lord, your lordship's judgment, my lord. 2007 1 GLT, page 33, my lord. And 2001 2 GLT, page 2640, my lord. 2 judgments I brought, my lord. First, 2007 1 GLT, my lord. Page 533, my lord. Para, my lord. 14, my lord. As stated above, in the instant case, the institution of departmental proceeding against the petitioner for incident which took place in the year 1992 cannot be initiated long after the petitioner had retired on superannuation and contemplated departmental inquiry, and proceeding against the petitioner is forbidden by the clause sub-rule 2, Rule 21 of the Assam Service Disciplinary of 1969, my lord. So, my lord, and another judgment, my lord, I brought, my lord, 2001 2 GLT, my lord. Guwahati High Court Imphal Bench, my lord. Para 5 and 6, my lord. Page number 2001 2 GLT 640, my lord. I had given, my lord. This judgment to this.
Which para?
Paragraph, my lord, 5 and 6, my lord. Six, my lord, everything is given, my lord, 5 and 6 in view of the able legal issued position which has been settled by the apex court, and also the provision of law laid down under Rule 9(2) of the Modification so and so, hereby opine that allegation event took place more than 4 years before institution of the said departmental proceeding and against the petitioner who is not permissible under the law and discussed above, my lord. Para 6, 5 is everything is there, my lord. So, my lord, main issue is, my lord, 4 years, my lord. It is the mandatory, my lord. So,
and in this state of Jharkhand case, where is the observation that it cannot be done after 4 years?
Yes.
Which part?
My lord, but within limitation, they can be initiated, my lord. But does in so far as, my lord. Page number Judgment and last, my lord. My lord. Page 217, my lord. F, my lord. Does insofar as provision is concerned that deal with the condition for initiation of proceedings and period of limitation within which such proceedings can be initiated, my lord. And my lord, if still pending, they cannot bill, my lord, para 13, my lord. A reading of Rule 43B makes this abundantly clear that even after the conclusion of departmental inquiry, it is permissible for the government to withhold pension only when a finding recorded is either in departmental inquiry or judicial proceeding that the employee had committed grave misconduct in discharge of duty while in his office. There is no provision in rules for withholding the pension gesture which when such departmental proceeding or judicial proceeding are still pending, my lord. Our rules also, there is no. If my lord, rule, my lord, clear that if my lord, departmental or judicial, my lord, is proceeding is petitioner is found guilty, my lord, found guilty, my lord. And they after retirement, they issued only so cause because of that withholding my pension, my lord. And very interesting, my lord, my case is concerned, my lord. They issued so cause notice. Please, my kindly see. So cause notice was issued on 30/5/2022. And they says that if you inspect the documents, and I write a letter on 6/6/2022, they did not even 6/6/2000 page 51, my lord. They did not given even any documents. Just they by as a tool for stopping my pension, my lord. I was retired, my lord. My lord, after
Provisional pension you are getting.
yes, only provisional pension. I tell you cannot be issued.
All right, yes, Mr. Salih.
Yes, Lordship. Lordship, that was my only submission, Lordship.
All right,
I mean,
heard Mr. N. Bora, learned counsel appearing for the writ petitioner. Also heard Mr. H. Shalia, learned
responding on 1 and 2, Lordship.
standing counsel, finance department, Assam, appearing for the respondent numbers 1 and 2. Mr. R, you want to say something? R.K. Talukdar, learned standing counsel, accountant general, bracket A&E, bracket close, Assam, has appeared for the respondent number 3. First up. The writ petitioner herein was serving as the senior finance and accounts officer in the Animal Husbandry and Veterinary Department in the government of Assam. Full stop. He was also holding the additional charge as finance and accounts officer in the Directorate of Social Welfare. Full stop. The petitioner has retired from service on attaining the age of superannuation with effect from 30/11/2021. Full stop. While in service, an FIR was lodged against the petitioner, based on which ACB PS case number 19/2016 was registered under section 120 bracket B bracket close /420/409 of the IPC, read with section 13 bracket numerical 1 bracket close bracket small d bracket close /13 numerical 2 bracket close numerical 2 in bracket of the Prevention of Corruption Act 1988 on the grounds of corruption having been committed by the petitioner. Full stop. He was also arrested on, have I mentioned about arrest? He was also arrested on 27/2/2017 in connection with ACB PS case number 19/2016. Full stop. However, by the order dated 29/5/2017 passed by this court in bail application number 513/2017, the petitioner was enlarged on bail. Full stop. months after his retirement from service, the respondent number, who has served the show cause notice? Secretary.
Secretary, my lord.
The respondent number,
2, Lordship.
respondent number
2.
2 has issued a show cause notice dated 30/5/2022, calling upon the petitioner to show cause as to why departmental proceeding should not be initiated against him on the 2 charges brought against the petitioner. Now, then you write, months after his retirement, a disciplinary proceeding, a departmental proceeding was initiated against the petitioner, and the respondent number 2 had issued show cause notice dated 30/5/2022, calling upon the petitioner to submit his statement of defense within 10 days. Full stop. The allegations brought against the petitioner in the form of 2 charges was that connected with financial, connected with negligence in duty and gross violation of financial procedure and rules. Full stop. Assailing the show cause notice dated, assailing the charge sheet dated 30/5/2022, the petitioner has approached this court on twin grounds. Firstly, that the authorities cannot initiate disciplinary proceeding against, firstly, that in view of Rule 21, bracket small b, bracket small Roman 2 of the Assam Pension, bracket service, bracket close rules, 1969, the authorities would not have initiated departmental proceeding against the petitioner in respect of an event which took place more than 4 years before the institution of the departmental proceeding. First up. Secondly, there is no valid ground for the authorities to withhold the pension of the petitioner years after his retirement. First up. In support of his above stand, Mr. Bora, learned counsel for the petitioner, has invited the attention of this court to the provisions of Rule 21 of the Rules of 1969 and has also relied upon the decision of the Supreme Court rendered in the case of State of Jharkhand and others versus Jitendra Kumar Srivastav and others, reported in 2013, bracket 12 SCC 210, as well as another decision of this court rendered in the case of Sushil Kumar Borua versus State of Assam and others, reported in 2007, bracket 1, bracket close GLT 533, to argue that the departmental proceeding initiated against the petitioner was barred under the law and therefore would not be maintainable. Full stop. Mr. Bora further submits that the authorities cannot withhold the pension of the petitioner. Mr. Bora further submits that the respondents cannot refuse to settle the pension of the petitioner since there is no valid legal proceeding drawn up against the petitioner wherein he has been found to be guilty. Next up. Mr. Chalia, learned counsel for the respondent numbers 1 and 2, on the other hand, has fairly submitted that there was delay in initiation of departmental proceeding against the petitioner
Due to non-receipt of relevant documents from the
due
social
to
welfare. Department.
non-receipt of relevant documents from the social welfare department. But according to Mr. Chalia, if 3 months time is granted, then the departmental proceeding again drawn against the petitioner will be concluded. Full stop. After hearing the submission of learned counsel for both the sides, the issues that would arise for consideration in this case is as to whether the departmental proceeding drawn against the petitioner wide charge memo dated 35/2022 was maintainable in the eye of law, and if not, whether there is any valid ground for the authorities to withhold the pension of the petitioner. There is no dispute in this case that the event referred to in the memorandum of charge took place more than 4 years prior to the service of the prior to serving the charge memo. As a matter of fact, the incident referred to in the memorandum of charge relates to the year 2016.
2014, my lord.
2014.
16/10/2014.
Relates to 16/10/2016.
14, my lord, as per
16/10/2014.
14, my lord.
Full stop. The criminal case was also registered against the petitioner in the year 2016. What had happened to the criminal case?
No, my lord, no, my lord, that is.
Acha, 2016. Rule 21 of the rules of 1969 permits the governor of Assam to withhold or withdraw pension or any part of it, whether permanently or for a specified period, and also the right to order recovery from pension any pecuniary loss caused to the government if, in a departmental or judicial proceeding, the petitioner is found guilty of pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement. Rule 21, bracket B, however, puts certain conditions if such departmental proceeding is initiated after the retirement of the pensioner. Rule 21B is extracted herein below for ready reference. Yeah, 21B and C. The B and C are quoted herein below for ready reference. From a plain reading of the provisions of 21B, bracket 1, bracket 2, and bracket 3, as well as small c, it is apparent that no legal proceeding or departmental proceeding can be instituted against a retired employee in respect of an event or cause of action which took place more than 4 years before such institution. Full stop. Next paragraph. By interpreting a perimetry provision contained in the form of Rule 43. No, I don't reckon. Rule 43B of the Bihar pension rules contain perimeter provision such as 21B. Full stop. By interpreting the provisions of Rule 43(b) of the Bihar pension rules, the Supreme Court has observed in the case of Jitendra Kumar Srivastav and another that the proceedings will have to be initiated within the period of limitation prescribed under the rules. Full stop. Next para. In the case of Sushil Kumar Borua, this court, after interpreting the relevant provisions of Rule 21B bracket small 2 of the rules of 1969, has held as follows. Para 14 to close quote koribo. Similar is the view expressed in an earlier decision of this court rendered in the case of Nabam Rameshwar Singh versus State of Manipur, wherein, by interpreting Rule 9 bracket numerical 2 bracket close bracket small b bracket close of the Manipur Civil Service bracket pension bracket close rules, 1977, it was observed as follows. Quote para 6. From a bare reading of the provisions of Rule 21B, in the light of the law laid down in the judgments referred to above, it is crystal clear that in case of a retired government servant, a departmental proceeding can be initiated against him, her, after the retirement only if the event and or cause of action had arisen less than 4 years before such institution. If the period exceeds 4 years, the initiation of the departmental proceeding will be barred under the law of limitation prescribed by the rules, and therefore the proceeding itself will not be maintainable. In the present case, as noted above, the departmental proceeding against the petitioner has been admittedly and evidently initiated in contravention of the time period prescribed in Rule 21 bracket B bracket close brackets small 2 bracket close, and therefore the same cannot be held to be tenable in the eye of law. For the reasons stated above, the memorandum of charge dated 30th of May 2022 is hereby set aside. Since there is no other legally justifiable ground within the ambit of Rule 21 so as to withhold the regular pension of the petitioner, this writ petition is directed by issuing a writ of mandamus upon the respondent numbers 1 and 2 to forthwith take steps for settling the pension of the petitioner in accordance with law. The aforesaid direction be carried out within a period of 3 months from the date of receipt of a certified copy of this order. Which petition stands allowed.
Pension and other service benefit.
Pension and other service benefits.
Much.
Admissible under the law.
Much.
Yes. You go. You can go. Sorry. Last item.
Item 52.
Go together.
With regard to the appointment of the arbitration.
Yes.
I had placed some judgments on the last occasion where by which the rights have been forfeited because they did not take the action within the 30 days period, Your Lordship.
You relied on data switchgear.
Yes.
It is there in the record.
I had placed Your Lordship, but Your Lordship had returned back the
Which is the first judgment, data switchgear.
yes, data suit. Yeah, yeah.
So what is this now? An arbitrator has to be appointed.
Lordships.
And as per the new
Who
panel,
will be the arbitrator?
Lordships, yes. Now lordships have courts have to appoint arbitrators. We have to discharge our duty as per the statutory provision, lordship. So as per if lordships have to appoint, then lordship, the GCC will not apply lordship. Then the GCC condition will not apply lordship.
No, that is over. You have forfeited the
Lordship. Then lordship may.
Can you agree on a name from the panel?
yes, Your Lordship, the panel,
Lordship
there
may
are,
appoint. I have.
we have no objection. Anyone can be.
No, but both of you don't have objection, then why?
Justice H.N. Sharma.
I think I name part. I have no objection. It is.
All right, give the panel and data switch.
Lordship. From the panel, lordship may appoint. No any choice.
I would data to know.
Do you have the number of Justice H.N. Sharma? We'll keep it blank. Just ask his consent.
Yes, that has to be taken, Your Lordship. Because there are,
Panel, lordship.
as per the recent panel, there are 3 judges, Your Lordship.
The recent panel, lordship. Judges, High Court, judges.
Anyone can be
Lordship
appointed.
may appoint. We have no.
So Justice H.N. Sharma,
Yes.
We have no objection if lordship.
you are speaking to yourself. I can't hear anything.
I have no objection if lordship appoint anybody. I have no.
All right, all right, all right. And where is data switchgear? You give me.
I have given the copy, Your Lordship.
He is not there here.
I've just now handed. Dilo no, I meant to do. Data switch girl. 2 judgments I have placed, Your Lordship. I've just now handed over.
Deep trading and data switchgear.
Yes, Your Lordship.
Take down heard Mr. A. Biswas, learned counsel appearing for the petitioner. Also heard Mr. Kostov Gogoi, learned standing counsel, NF Railway appearing for the respondents. Full stop. This application has been filed under section 11 bracket 6 of the Arbitration of Conciliation Act, 1996, dated 1996, praying for appointment of an arbitrator so as to enter upon an adjudication in respect of the contractual disputes arising by and between the parties. Full stop. The facts of the case, in a nutshell, is that the petitioner had entered into a contract with the respondent number.
The respondents, Your Lordship. Respondent
No,
number 1
only
is the general manager. He will be the person, Your Lordship.
with the general manager.
The contract agreement is Annexure A, page 29, Your Lordship. It has been signed by the Chief Engineer Construction. But generally, it is the general manager who.
With the NF Railways, Maligaon, signed by the Chief Engineer /Con-1.
Yes, sir.
For execution of the contractual work, dated 12/2/2013. For execution of the contractual work. Where is the name of the work?
Lordship, in page 29, the entire work is there. It is a lengthy thing, Your Lordship, page Annexure A. In the second para, where is the agree between kilometers such and such?
The underlying portion.
The underlined portion.
Page 29, you will find it between KM. So and so and so and so, so and so.
Gauge conversion project.
Full stop. According to the petitioner, it had executed the contractual work and completed the same on 29/3/2016. Whereafter, a work completion certificate was also issued in its favor on 02/04/2016. Poster. Thereafter, the 6 months maintenance period was also thereafter, the obligations pertaining to the 6 months maintenance period was also discharged by the petitioner, which came to an end on 30/09/2016. Full stop. A final variation statement was prepared by the respondents. However, according to the petitioner, there was error in the variation statement, and therefore it had raised objection based on which objection and requested for a preparation of a fresh statement. When the respondents failed to respond to such request of the petitioner, it had lodged its final claim before the respondents on 13/9/2021. Full stop. When the respondents failed to respond to the final claim notice dated 13/09/2021 submitted by the petitioner, an application, a notice under Section 11 of the Arbitration and Conciliation Act, 1996 was served upon the respondents on 17/01/2022, raising a dispute in the matter along with a request for appointment of arbitrator. Full stop. The respondents had received the notice dated 17/01/2022, but instead of appointing an arbitrator, they had made a request to the petitioner to reduce the claim amount as mentioned in the notice dated 17/01/2022. Full stop. Acting on the request coming from the respondents, the petitioner had reduced its claim and thereafter served a fresh notice dated 15/3/2022, demanding reference of the dispute to the arbitrator. The respondents, however, did not take any steps for appointment of arbitrator and instead wrote back to the petitioner seeking waiver of the provision of Section 12(5) of the Arbitration and Conciliation Amendment Act, 2015. Full stop. Situated thus, the petitioner has been compelled to approach this court by filing the present petition. Full stop. It is not in dispute that there is an arbitration agreement by and between the parties in the form of, where is it?
Clause 64, Your Lordship. The
Clause 64 of the GCC.
GCC, and the amended is Annexure L, page 81, Your Lordship.
As amended. From time to time. And the dispute, and there is an arbitrable dispute by and between the parties. Full stop. The question that would arise in this case as to whether the respondents have forfeited their right to appoint an arbitrator, and if so, whether an order is required to be passed in this case by this court appointing an arbitrator. Full stop. Law is firmly settled since the decision of the Supreme Court rendered in the case of Datar Switchgear Limited versus Tata Finance Limited and another reported in 2000 bracket close 8 SCC 151 that which is the para
Para 19, it would be, your lordship.
that that if one party demands appointment of arbitrator by serving a notice under section 11 bracket 6 bracket close of the Act of 1996 and the opposite party does not make an appointment within 30 days of the demand, the right to make appointment of arbitrator does not get automatically forfeited. But if the opposite party makes an appointment, even after 30 days of the demand, but before the first party has moved the court under section 11, the right to make appointment of arbitrator by the other side ceases. Full stop. In other words, if the demand for appointment of arbitrator is not acted upon before the party making the demand moves the court under section 11(6) of the Act of 1996, then the right of the opposite party to appoint an arbitrator stands forfeited. Full stop. In the present case, as can be seen from the facts narrated above, the respondents have received the demand for appointment of arbitrator, but not to speak of 30 days. They had failed to appoint arbitrator till such time the petitioner had approached this court, and even at this point of time. Full stop. As such, this is a fit case where this court is required to pass an order making appointment of an arbitrator from the panel prepared by this High Court under notification number 47 dated 26th of April 2023. Full stop. The learned counsel appearing for both the parties have agreed that Mr. Justice so-and-so retired can be appointed as an arbitrator to adjudicate upon the dispute involved in this proceeding. Full stop. As such, in exercise of jurisdiction under section 11 bracket 6 of the Arbitration and Conciliation Act 1996, this court hereby appoints Mr. Justice so-and-so retired as the sole arbitrator. Is a sole arbitrator? Sole arbitrator to enter into the dispute by and between the parties and pass an award. This petition stands disposed of accordingly. So in case there is no disagreement, then she will consult you, then you agree on another name. First, we'll try for Justice H.N. Sharma.
Yes, your lordship.
But it has to be.
Yes,
on
the consent has to be procured.
All right.
Highly obliged.
So this process may be ultimately winding up in Monday.
Yes.
So let the order be typed out and then on Monday. Yes. All right.